can mention on diary number because of urgency. It is not. I am mentioning diary number, my lord. I am giving the diary number only.
Any urgency?
Yes, my lord. My urgency, my lord. My position is merit list 24. Below below 24, they are giving for counseling to choice of posting, my lord. Let it come tomorrow, my lord.
Lordship, remember, this is a matter relates to suspension 2020. Matter was had by your lordship.
2020.
I am placed under suspension. Lordship had this matter.
Next week we have.
Like, date let it come tomorrow, your lordship.
Next week.
Evaluation of the March.
Next week we have. You all next week, whichever you want. Tomorrow I am not taking, excepting. Yes.
11 August. Matter is not listed, madam. 11 October.
Memo for withdrawal, madam.
My lord, 2016 matter, my lord. Pension matter, my lord. 2016.
Why?
She did not get pension after the death of her husband, my lord.
Make use of the mic.
My lord.
Make use of the mic.
My lord. Petitioner is the widow. She is not getting, the opposite parties are not releasing her pension, my lord.
Next week it will come.
My lord, it is an arising employee compensation case. My lord,
Compensation.
23 Act. I guess my employee compensation case, my lord. For fresh admission.
Employees Compensation Act 1923. Again, come to me.
Yes, my lord.
May not be, no? It's a labor matter.
Special event.
Very specially assigned to.
Yes.
Just take it and post it before the appropriate bench. Just make it note.
My lord,
Post it for appropriate.
pardon. Face admission matter. Face admission, regulation matter.
Regulation.
Pardon? They mentioned one is contempt matter, another is the termination of 2024 matter.
24. Yes, we got.
My lord, on 2087, your lordship issue notice to the opposite party and are directed to list this matter after 3 weeks.
Yes.
In the meantime, your lordship similar matter, your lordship disposed of many matters.
Disposed of many matters.
My lord, similar matter, covered matter.
Pardon to mention, my lord, I am on VC, my lord.
Yes.
My lord, item number 31 may be adjourned to some other day because of we needed to file the rejoinder, but the petitioner in the issue has been 70 years old, my lord, so that we couldn't file it within the time. So it may be adjourned to some other day. We will file the rejoinder within that time, my lord.
Rejoinder.
Yes, my lord.
From the other side.
I don't have actually numbers of the other side, my lord.
Wait, because getting the matter itself is difficult thing in this court. Therefore,
yes,
we do not know why matter is posted. Maybe it's of other side also. We'll hear and we'll give time. Huh?
Yes, my lord. Much obliged.
1 second. Has it come? It must have come. Oh.
Judgments. Judgments. Item 59.
Adjournments.
Yes. Item 59, my lord.
59.
Yes.
Which year?
2024 and 25, 23.
24, 25.
Yes. Your lordship, similar matter, lordship had and posted other batch cases, posted to the second week of September. In that case,
second week of September.
Second week of September.
Second week of September.
This is the order, your lordship. And
this matter along with WP number.
This case is pleadings are completed. For that reason, your lordship fixed the second week of.
Call along with WP number.
The 2 cases have given the number, man.
In that?
Yes.
Yeah. Yes, pronouncement of judgment. I don't know what. Four review petitions we have taken up together, and one review petition of the government we have tagged to this. That's all. I have referred to sections 24A, 24 B24C of the Education Act. I have referred to the provisions of rules of High Court of Orissa 1948, chapter 7, 8 that were argued. And I have referred to Rule 26 of Odisha Tribunal Rules 1977, inherent power, etc. Then I have referred to 3 judgments which Mr. Rautrai gave in his written submission. And I have referred to Lord Coke's judgment, Lord Halsbury's judgment, then Apex Court judgment in Changalavara Naidu. Then I have referred to Broom's legal maxims. And earlier orders passed by this court in this petition. Thereafter, I have held that the review is not maintainable. I have agreed with Mr. Jena, Lenka and the other counsel who had argued. I have also just mentioned the scope of first appeal, the scope of second appeal. I have also mentioned what is the nature of proceeding before the tribunal, because section 24A(3) says appeal before the tribunal. Therefore, I did not treat the proceedings before the tribunal as original proceeding. If that is so, appeal becomes first appeal. 24C appeal to this court becomes second appeal. Ordinarily, the scope of first appeal is wider. The scope of second appeal is not that wider. That also I have kept it. That I kept in view because if second appeal is not wider, the review of second appeal order is still restrictive. On that logical basis, I have constructed the judgment. Okay, and in the above circumstances, these review petitions being devoid of merits and also lacking maintainability are liable to be dismissed, and accordingly they are. Courts having been reluctantly made is very reluctantly. I did not order courts, and Mr. Dash has referred to Supreme Court rules as if this court's rules. Since he said that it is by mistake he did it, I have not mentioned anything in this. In fact, I wanted to mention, because whether it is Supreme Court rule or this court rule, one should tell us. Otherwise, the entire judgment would have been in a different way. But I have not, as a concession to Mr. Dash, I have not made any comments on that. But he may inform me that court said like this. He will also see it online. Okay? Yes. And since you argued that review is not maintainable, and I agreed with that, your review is also rejected now.
States.
Yes, state's review is also rejected. The only difference is state's review I did not consider on merits, but this review I considered on merits also. I went through, I spent a lot of many hours, myself and my colleague spent many hours on this. And then we have structured this judgment. And I am not the final call.
God bless you.
Yeah. Little modification, little small mistakes are there. I will carry out them next. Item number 2.
May I please?
Yeah.
And here the order of the government in an appeal referred under section 91 of Orissa Development Authority Act. Yes, 91.
91(2).
Is under challenge. But the challenge is on the ground that, in fact, no opportunity of hearing has been given. Because prior to that, that appeal was disposed of under Annexure 15, and challenging that, the petitioner had approached this Honorable Court in WPC number 34272 of 2022.
What 7/12/24 order, it rejects your application for regularizations.
Yes, your lordship will get it at page 112.
112, 120,
128.
128. Right.
112. The order passed by this honorable court in the previous writ petition.
No, not that. It only sent it for reconsideration.
Reconsideration, but there the question is, your lordship have a glance in the result, that is page paragraph 14.
112.
112.
What to 112?
In the result, the writ petition stand allowed as a necessary corollary. The impugned order under Annexure 15 passed in UC Appeal number 22 of 19 by opposite party number 1 is hereby set aside with a direction to ensure its disposal afresh within next 3 months, subject to decision on the request of the petitioner on regulation to be taken forthwith. Prior to that, my lord, it was
Then without being influenced.
yes.
That you are not reading.
It is made clear that any such decision in appeal shall be on the merit and in accordance with the law, providing opportunity of hearing to the parties involved and without being influenced by the observation by the hearer.
Therefore, it is a open remand.
Only remand.
Open.
Yes.
Now you have to show-
only, but there it was specifically mentioned this by this order. It has been specifically mentioned that month subject to the decision on the request of the petitioner on regularization to be taken forthwith.
That
Because
means
prior-
for your, if you seek adjournment, etc., on that.
Yes, my
it has nothing
application,
to do.
my application for regulation is pending. So your lordship was pleased to direct the authorities that first that regulation application should be considered. After that, the appeal. Anyway, but still then that application is pending. On the amnesty scheme, that application is pending for regulation of the deviation.
Is there any amnesty scheme? You
Yes,
appear
yes.
for the opponent.
No, my lord. I am it's a multi-story building
You
of
appear
8.
for whom?
I am the flat owner.
Private opposite party.
He was the developer. Now he is staying along with us in one of the flat, pretending to be the owner, who was the developer on behalf of the landowner as the power of attorney holder. Now neither the land owner is there, nor we all are agitating our problem since 2016. 2018, the demolition order passed, considering that there is a clear violation of the construction. And the multi-storied building, application of compounding the unauthorized construction doesn't arise. It was held page 80, 2010. Thereafter, 2014.
Page 80.
Yes, your lordship.
Where is that?
Page 18.
80, my lord.
Yeah. Fifth floor, some portion is added.
Yes, not only that, my lord, even if it is not on,
It exceeds 15 meters.
yes, not only this, my lord, during the entire proceeding right from 2017 till date, even the earlier proceeding I have brought to the notice of this honorable court, during that also he continued with the construction. We are put to such a position, one of us we all are aged people, retired doctor, retired bank officers, one of us are already sold away. And he is creating such an atmosphere so that, and he says, I have sold. 2015, our colleague or a person who purchased along with us.
What is your right?
Yes.
You are only a builder.
Yes, ma'am.
After everything is built, you go away under the scheme of the law.
Yes.
What is your right to make? Why did you build additional?
So additional ballot, that is the reason why I filed the application for regulation. Your
Where
lordship,
is the amnesty scheme?
yes, they have not considered that application till date, and
No,
that
where is the right to consideration? Under what rule it should be considered?
that they floated a scheme,
Where is
amnesty scheme.
where is that?
Page 60 is my application.
Contrary to state interest.
I am asking, kindly answer.
Yes.
Where is the scheme? please understand simple English.
The scheme I have not annexed, but pursuant to that scheme, my application is pending. And
How
that
can I assume the scheme?
Yes,
I am
sir.
an outsider.
Yes, sir. But that has been taken into consideration and the steps have been taken. My lord, now the fact remains.
Unless you answer court's question,
No, no,
I dismiss your petition.
Yes, I will scheme. I will file the scheme. The scheme is there. That is why I filed the
I do
application.
not know. I don't carry any scheme in my pocket.
Yes,
I'm
sir.
an outsider. You should tell the law. Get the order from my hands. Counsel for the petitioner seeks short accommodation for producing a copy of the amnesty scheme under which he claims to have made the application for regularization of unauthorized structure. First time granted, subject to the warning that if not produced, then a heavy adverse inference may be drawn against the petitioner. Call this matter for further hearing on 4/9. Yes. On 4th. Whichever date you want.
Yes, yes, sir.
I'm seeking for adjournment on behalf of Mr. Alil Patnaik. He is ill, my lord.
If you want time,
My lord.
which year matter?
Item 3,
25.
my lord.
It was adjourned earlier.
No, I am not got instruction. He is ill, my lord. He has requested me to take adjournment.
No, I am asking you. What is adjourned earlier? The business of the court is not go on adjourning the matter.
No, once.
To do justice.
My lord.
Therefore, you have called me to this.
My lord.
Is it not?
My lord.
If I go on adjourning the matter,
No, he is ill, my lord. He is ill, my lord. He is unable to move. Mr. Alil Patnaik.
call this matter adjournment reluctantly granted by way of 2 weeks on the health ground, in as much as earlier also matter was what. Next, item 4. Make best use of me.
My lord.
Argue wherever you make good case. I grant relief. I am here to grant relief. I am doubly cautious when dismissing the matter. I am aware that nobody comes to court happily. Therefore, if somebody has come, there is some injury. Make use of me. Don't go on asking time again and again. Listen, and without answering court's question. Yes.
May I please, Your Lordship?
Yes, sir.
Well, this is my third round of approach before Your Lordship. My claim is I was a general caste candidate.
Fixation of seniority.
Yes, as per the catch-up rule. And the government now rejects on the ground that since by the date of preparation of the gradation, revised gradation list showing me senior, I have retired from service, I cannot get stepping up pay of it. Whereas throughout my junior in the reserved category, he drew more pay than me. Your Lordship may kindly see page 44.
Issue emergent notice. Mr. Learned AGA. All AGA.
No.
You have to say that.
Yes, my lord. Both the parties AGA.
AGA requested to accept notice for respondent. First off, since this is third round of litigation, call this matter immediately after completion of pleadings. And pleadings to be completed within 6 weeks. Item 5.
Grievance petition pending before the OP number 4. Annex of 2, man.
Which is that petition?
Regarding the pray for a 1 month salary of the petitioner, man. 1 month. Well, they have given the salary match in April 2000, but
Increment also to be given.
man,
Increment also.
man,
Salary and increment both.
man.
You consider that? Yes, thank you. The short grievance of the petitioner is as to non-consideration of his representation dated 24/7/2025, wherein a demand is made for payment of arrears of salary for the month of January 1999 and also for awarding the increment with effect from January 2000. First, learned counsel for the petitioner submits that when a representation of the kind is given by an employee, state being the model employer has to grant redressal in accordance with law and in a time-bound manner. First one. Next paragraph. Learned AGA on request appearing for the opposite for OPs graciously agrees with the suggestion of this court that the jurisdictional OP has to take a call on the subject representation in accordance with law. First one. In accordance with law and within a time bound with. First one. This is appreciable. Next question. Under the above circumstances, petition is issued of 6 weeks for compliance, which should include conveying the result of consideration to the petitioner. First up, it is open to solicit. Now, no course.
Item 6.
If petitioner is a class 4 employee claiming regulation of his service from his initial date of appointment,
Similar matter,
your lordship issue notice
call along with
on behalf of opposite party number 1, my lord senior.
That's all copy on me, Miller. Your lordship may record my name and direct me to appeal. It's still also my name.
Issue.
OP 1 and 2.
emergent notice. Learned AGA appears for
3 and
On behalf
3 and 4.
3 and 4.
Yes.
3 and 4. Learned panel counsel Shri appears for OP numbers 1 and 2. Always central government should be made, Union of India should be made first respondent. Then
Here is clear.
state should be made second respondent. This is the order. Standard books on pleading say that way. You can't make a respondent, the Union of India, the last respondent. That's not the order.
Here is
no, law does not say.
Sorry. Here is claim against the opposite.
Whomsoever. If you there are Odger's pleadings, famous pleadings by English author. He says we should be made in the order. Though it is not required as such, I'm just telling you. So that there will be some this one. Yes.
That matter may call along with
this matter along with
serial 10 and 17 also.
70 also said.
6,
Serial
10,
number 10 and 17.
17. There also
Yes. Same opposite party.
Okay. Call along with signs. Okay. Next.
Item 7.
May I please ask? Petitioner applied for caste certificate before the
Caste certificate.
Yes, ma'am. Before the Tahsildar Raikya, but the Tahsildar rejected my application. Then the petition prefer an appeal before the appellate authority, collector cum appellate authority, Hon'Ble. That has been pending since last 5 years, ma'am.
Last 5 years.
Yes, ma'am. Last occasion, ma'am.
Because all our plans are 5 years plans under the Constitution.
Yes.
People are elected for 5 years. The budgetary allocation generally.
Several times, my lord, the petitioner approached the authority, but that has not been.
The short grievance of the petitioner is against the long pendency of caste appeal number 5/2020. First time, learned counsel for the petitioner rightly submits that speedy justice is a facet of Article 21 of the Constitution of India as held by Apex Court in a category of decisions, and therefore a direction be issued for expeditious disposal of the subject appeal. First time. Next paragraph. Learned AGA, Mr. You have to dispose of the appeal.
Yes.
You can't keep it pending for 5 years.
I have no instruction whether appeal is pending or not.
This petition will
If
say that.
If pending.
If pending.
Pending, ma'am.
If pending.
Because I am the counsel of that pending also.
Oh. Learned AGA on request accepting notice for the OPs graciously agrees to instruct the appellate authority to hear and dispose of the subject appeal if all contentions are kept open. First off, this is appreciable. Next paragraph. One sentence. He enters a caveat that the question of considering the appeal would arise if it is still pending. First off. Next paragraph. in the above circumstances, petition is disposed of, directing the who OP number
Sole opposite party.
directing the OP to hear and dispose
Appellate authority.
to hear and dispose of the subject appeal and report the compliance of the disposal of the same to the Registrar General of this court within an outer limit of 4 months. First comes 4 months. All contentions of the parties are kept open. Who is your opponent party?
Opponent party collector. Tahsildar.
Rashid.
Yes, ma'am.
All right.
9 also same, ma'am.
No, of course. 9 also same.
Yes, ma'am.
Appeal number?
Appeal number, madam.
Why 5 years?
320.
320 of
2020.
2020. Same one. Why they are keeping pending for 5 years? Are they sleeping with the appeal papers as using it as below? 5 years. We will keep. We can't say more also because we have pendency since 2008. If our officer comes and tells pendency in your court is 2008, why are you directing me? I have no answer actually. Anyway, he has to consider that.
Yes.
Yes.
Item 8.
Now, no cause. Okay.
Item 8, madam. The petitioner has prayed to grant a revisory salary similar to Shripad, my lord, and so.
Order for differentials of arrears of salary.
Yes, yes.
Any representation you have?
Yes, on the annex of 3, madam.
What in that? What you have ordered?
Annex of 5 series, my lord.
Similar order.
Yes, madam.
You have changed everything now.
Yes.
Then. Okay.
Item 11.
11 plus is not matter related to promotion as well as extension of officiating pay, second round of litigation. And the earlier
Librarian. Promotion to chief librarian post.
assistant librarian to chief librarian.
Under which rules?
Lords, university rules, lords.
What's your right to be considered?
Lords, according to rule, the persons, lords, this is the rule, rule 36, lords, you kindly see.
Kindly read. Kindly read.
Lords.
Do you have one more copy?
Yes, I have.
Yes, give that. The feeder post is librarian.
Assistant librarian. They say there is the opposite party 1 and 2 say there is no provision for such promotion from the post of assistant librarian to chief librarian. But they have given promotion millers to the succeeding persons who have joined after my retirement. They have given benefit. They have given benefit to my predecessor, but they have denied me. In the meanwhile, I have got retired from service. So this Hon'Ble Court directed them to reconsider my case, even extending the benefit of officiating pay.
No, sir. Feeder post to the chief librarian.
Millers,
The feeder.
Lordship, here they have no specific rules, but Lordship kindly see annexure.
That makes no sense.
Yes, Lords. Annexure 2.
They have given promotion to others.
That I have.
No, that makes no sense. The question is,
Yes, Lord.
right to promotion
Lord.
arises provided that you are holding the feeder post.
Yes, Lords. Lordship kindly see page 22.
22.
Yes, Lords.
No, from the rules you have to show.
Yes, Lord. That is the rule.
To be shown.
No, that I will bring to Lordship's notice. Also kindly see that is the rule. Promotion.
Promotion.
Page Lords, and read application page 22. Lordship can see read application.
What it said, you have right of promotion.
Yes, Lord. That is relating to promotion of Orissa universities. That which I am bringing to Lordship's notice. Rule 13 sub rule 2.
Rule 13
Sub rule 2. Sub rule 2A. Deputy registrar and its equivalent class 1 post to the extent of 1/3 of such post vacancies. This is with regard to promotion.
Or its equivalent cadre, class of persons.
Yes, my lord.
You are equivalent.
Yes, my lord. So, also kindly see next page, my lord's university statute I have enclosed in my writ application, page 23.
Now, where is the equivalence?
That there I will bring to lordship's notice, my lords.
23.
Yes, page 23.
Class
This is the university statute, my lords. Your lordship kindly see Schedule B classification of post.
librarian, chief librarian.
Yes, my lords.
Where is assistant librarian?
No, assistant librarian, they have no specific rules. Therefore, I have enclosed, my lords, rule, your lordship kindly see rule 36.
Rule 36 from
Of that rule, the book.
The
my lords.
book.
Yes, page 17.
is 17.
Yes.
In any particular point, including the qualification for recruitment, these rules are silent. The corresponding rules operating in the state government or clarifications prescribed by the state government in respect of its employees shall apply, but that is and this. Under the state government rules, there is a
That I have enclosed also. Your lordship kindly see
Where is that?
page
Page 39.
Page 39 minutes. Copy of the promotion decision meeting. Page 24, 26. Annexure 3. State government resolution.
Which says,
More particularly, your lordship may kindly see page 25. Librarian.
librarian.
Yes.
Where is assistant librarian?
Yes, that I will bring to lordships. Surplus 2. In order to be eligible for the post of librarian, the officer must have rendered continuous service at least for a period of 5 years as an assistant librarian in the scale of the sword. So, this is the rule.
That is from assistant librarian to librarian.
Librarian.
But not chief librarian.
No, that is the equivalent post. In the university, they treat librarian as chief librarian. That is the only one post is available, which the assistant librarian post usually gets the promotion to the post of chief librarian. Therefore, your lordship kindly see equivalent employees, they have got the benefit.
All right, let us see. Issue notice. Not fully convinced. Anyway, issue notice. AGA is there?
State.
Why AGA?
Nominal.
My lords,
You will make in every case state is a party.
Because they seek
You have to
advice.
trouble the government advocate.
No, they seek advice from the state. It is their plea that we seek advice from the state, thereafter we extend the benefit.
AGA?
Yes.
AGA 1. You are 1. Oh, AGA for OP1. Emergent notice 2. The rest. Since this is second round litigation, post this matter immediately after service. Yeah.
I will take notice by speed post. Can I pray for a specific date?
Date I cannot.
So speed post can be not within a week also.
Speed post. No date will be given, but you can take it speediest post.
Plus, can I pray for one thing? Plus, some date of
No date will be given.
No date of
stage.
Plus, some places date of retirement has been wrongly typed. Can I be permitted to correct it?
With the permission of the court, the net counsel for the petitioner has rectified date of retirement in the pleadings. Give the copies. Registry to effect similar changes in the, what do you call it, in the web copies? E-copies. E-copies. Okay. Yes, just rectify it with signature. Wide order. That order has to be printed. Okay. Yes. Item 12.
My election to the post of sarpanch was questioned by the private opposite party number 3.
This spoke to London friends. Okay.
Sorry to
Your election.
concern, my lord. This is the election matter, so court number 3 assigned to court number 3.
Assigned to court number 3. All elections are before court number 3.
My lord. That is Justice R.K. Naik.
Learned, you are for
My lord,
Of the private.
he is correct. It has to go to before old court number 3.
let it go.
My lord, I am helping him.
No, if you help me also by permitting to pass the order.
Your lordship may dismiss my writ application. The point which I
Where is power to dismiss? I can't dismiss that way because you are saying it's a writ.
because the order which has been challenged is absolutely correct order.
You are saying it because I cannot pass that order.
No. In that court also I would have said this. My lord, unless I am convinced, how can I convince your lordship?
Even his senior is.
No, I can't do that. I have no power. Because see that state of Rajasthan versus Swine. The judge shall take up the matter only when it is aligned by the Honorable Chief Justice of the High Court.
My lord, may I pray one thing?
Yes.
Can it be listed tomorrow before the appropriate bench?
Why, if it is a dismissal, where is the urgency for getting suicide?
My lord, sometimes suicide is better.
Post this.
Because the matter is posted tomorrow in the trial court. I'll be helpful by your lordships by receiving one less phone call in the evening.
I can't. That is very difficult. Yes. Post this matter before the roster bench.
Justice R.K. Patnaik. People
No,
know.
you can't say that. After examining the subject matter.
Tomorrow your lordship may say.
No, I can't post. How can I order?
No, your lordship may only direct the registry to post at an early date.
What? First, come on, at the earliest. Okay.
Item 13.
May I please, your lordship? In this matter, the petitioner is working as a lecturer state scale in NC Auto College, Jajpur. By the Annexure 1, he has been transferred to the rank of assistant professor grade 1. That is under challenge that since I am in a different post.
You cannot be posted to a lower post.
Not a higher post.
If you are posted to higher post, how you are aggrieved?
I say that when my post is there, I will join that.
That's all right. Yeah, how you are, where is the grievance? If you are posted to a higher post, where is the grievance?
Grievance, they will not pay me the high scale of pay.
If you are worked, you will be entitled to.
No, that is not the practice. That is not the practice.
No, that's the law.
I know.
Aditya Paul says that.
As long as I am appreciating in a higher post, I am entitled to that scale. I don't dispute.
Yeah.
But what is happening in the higher education department? They are posting all the lectures and you work in that post, you work in that post. Now, Annexure 4, the composite college was created and we belong to the higher secondary education. We are junior lecturer of higher secondary education. They said that you should be posted in a degree college which has also +2. That is higher secondary education is there. That is called composite college. Now in composite college, I am to work in the junior lecture scale, lecture scale in the higher secondary course.
No, but that scale will be better than yours.
If they grant me that scale of pay.
If your scale is protected, you cannot have grievance.
In a higher post, they are
They will be giving more than.
No, that they are not giving.
No, that for a separate cause of that question arises after you work there and they release the salary. You can't anticipate.
Now they have issued the order saying that you are transferred as assistant professor.
Yes.
In Annexure 1, you will see
the grievance of the petitioner is against the transfer order.
You will
dated
see
15 August 2025, a copy whereof awaits at Annexure 1, whereby he has been transferred allegedly to the post which is a bit higher than which he held, which he now holds by way of plea. First up. Next paragraph. Learned AGA appearing for the OPs submits that there is no legal injury in as much as no service condition of the petitioner would be prejudicially affected. First up. This is a case of damnum sine injuria. First up. Therefore, no right, no writ principle arises. Next paragraph. The above being said, the learned counsel for the petitioner complains that he may not get the salary of the post to which he is now being transferred, and therefore some observation has to be made. First up, he is yet to report for duty and work there. First up, the salary or emoluments would accrue only after the month end. First up, no advance relief in matters like this can be accorded. First up, in the above circumstances, petition is dismissed as being not made.
You know, observe that in the event I am posted in the higher post, I can approach the lordship for that scale of pay.
No, you are not entitled to scale of pay. You are entitled to emoluments because you don't have right of lien to that.
No, Odisha service code, that is called appreciating scale of pay.
Anyway, if you have other grievance that arises after working,
yes, I am conscious. What I am saying, you must give that liberty.
If there is any grievance subsequently arising, liberty is reserved to the petitioner to take appropriate recourse in accordance with law.
Dismiss may be disposed of.
Disposed of.
Item 14. May I please, Lord?
Yeah.
Here, my lord, my prayer is, my lord, for correction of my Aadhaar card, my lord. The Aadhaar card, my lord, page 10, you lordship kindly see, there is the title is wrong and the Odia name is also wrong. That much, my lord, I want to correct.
Secondary. In your matriculation.
No, as per matriculation, the name is, in the English name is the right, my lord. But the Odia name is wrong and the title is also wrong as per the certificate.
Who appears for the you?
We are appearing, my lord. We are appearing. Mr. Guchat is there. We are appearing.
Yes, DST. Where is your representation?
My lord, it is online, my lord. When, my lord, the online application...
my lord, I've just time playing, my lord. Usually these cases are coming, the director, I talked to the director, he expressed me, mere correction is not accepted by the portal, unless until they are not supported by the substantial document. If they want to any correction, then they have to upload the portal and that should be clear by the system only. It cannot be corrected manually. So I will take instruction. What can be done? Then I will apprise the court accordingly. Lordship may directly. It can be sorted out.
Learned DST issue notice. Learned DST accepts notice. For how many respondents?
1, 2, 3.
4 is there. 4 has no role to play. Collector he has made a party.
Why collector you made? Petitioner to delete. Or OP number 4 from array of parties. And with leave of the court, he has complied with this direction. Now do that.
It is online file. I will file a consolidated cost type.
Then only direct to delete. Sorry, that's all. Next. Item 15.
May I please, my lord? The petitioner now working as a matron, my lord. In the BBC school, government higher secondary school, for hearing and impaired manner. And she had required qualification for appointment as a...
Kindly have a mic nearby. Yes.
Well, she had... now she is working as a matron manner. In BBC, government vocational higher secondary school of the hearing and impaired manner. She had a special qualification for appointment as a trained intermediate manner.
To others, they have given that salary, pay scale.
My lord. Annexure 1, my lord, she was appointed on contractual basis based on the Group C, Group D contractual service rules 2013 as a matron, my lord. Under Annexure 2, my lord, government decided to regularize their service. And accordingly, by according Annexure 3, my lord,
she has been regularized.
Regularized. That her name is at serial number 11. Post held TGRs.
Tapaswini
Parida.
Now what happened?
Now, my lord, and the persons, those who are regularized along with the petitioner, my lord, that is Annexure 4 series, they are treated as a trained intermediate teachers officiating, and they are
getting salary in that pay scale.
Yes, my lord, got pays 14, my lord.
Now we will direct consideration of your representation dated 2/5/25. All right?
My lord.
All respondents are AG.
My lord, I may be excused, my lord, in prayer portion, my lord. Instead of Annexure 4 series, I wrongly typed as 5 series, my lord.
5 series.
Yes.
Petitioner on the oral request is permitted to rectify the annexure series
Prayer at
in the prayer column.
prayer number 2, my lord, last was second.
Anyway, the prayer column I have said, you just rectify it. Okay? Okay. The short, the petitioner, we call that. Petitioner has made the substantive prayer in the following language, following text. Item number 2, Roman 2. 2 and 3. 2 and 3. Okay. Next paragraph. Learned counsel for the petitioner, drawing attention of the court to the representations at Annexure 5 series.
Annexure 6, my lord.
6 series.
6 only once.
6. Annexure 6 dated 2/5/2025 submits that a request has been made to treat her as TI teacher as per the order of regularization dated 1/7/2023, and as a consequence fix her pay at rupees 29,200 in level 8 in terms of
Level 8, cell 1.
level 8, cell 1 of pay matrix of ORSP rules 2017 with effect from the initial date of joining. First one. Learned counsel for the petitioner submits that if a direction is issued to the jurisdictional OPs to take a call on the subject representation in a time-bound way and in accordance with law, his client would be satisfied. First one. Next paragraph. Learned AGA, on request appearing for the respondents, agrees with the suggestion of this code that the subject representation needs to be considered by the jurisdictional OP, and its result has to be conveyed to the petitioner within a reasonable time and in accordance with law. First stop. Next paragraph. One sentence. This is appreciable. In the above circumstances, petition is disposed of. Time for consideration is 8 weeks, which would include the time for conveying the result of such consideration to the petitioner. First of all, contentions are kept open. Next paragraph. It is open to solicit permission, etc. Now, no cause.
Item 16.
Item 16, please, ma'am. Then, my lord, petitioner's prayer for regularization has been rejected by Annexure 11, page 37, my lord.
How long he has worked?
From 2008, my lord, he has been continuing as assistant teacher, my lord. They have rejected by Annexure 11, page 37.
On what ground?
Ground is that he has not yet acquired B.Ed training as required under the provision of 1993 rule.
Yes, if you do not have a qualification.
My lord,
How will you
Annexure
get
12, they have regularized similar footing persons, and they have also issued a clarification, Annexure 12, page 38. Saying that, my lord, it is to clarify that the contractual teachers who have been regularized may avail untrained scale prior to completion of B.Ed training, and after completion of B.Ed qualification, they may be eligible to avail scale of pay as trained graduate teacher. So, my lord, for regularization, B.Ed qualification is not necessary.
You have made one sentence. So do not pass.
Sorry, ma'am.
Should not your addressee process your statement?
Sorry.
Is it not? After speaking one sentence, you should keep quiet. You should see its impact on the mind of the listener. Okay, then you should go to the next sentence.
Sorry.
Okay. So you mean to say, for regularization, B.Ed is not a precondition. Once regularization is done, then they will be given time to complete the B.Ed and get the emoluments.
Yes, ma'am.
Appears to be sensible.
It is given chance to long period to complete the B.Ed examination.
It was given.
Yes.
No.
From 2013, he was asked to complete B.Ed examination.
No, what he says is, to other people you have regularized. And this Annexure 12 says, you will be entitled to particular emolument after you complete the B.Ed. Otherwise, you will not be entitled to it. How can B.Ed be a bar to regularization is his question. You accept notice and file.
I'll file.
Issue emergent notice. Learned AGA accepts notice. First off, since a very short point of law is involved, call this matter immediately after pleadings are complete. First, pleadings to be completed within 8 weeks.
Item 18.
Yeah.
Here, my lord, the petition advances, my lords, Annexure 4, that is the government resolution, wherein the revised scale was given to the government school teachers in a particular dates and the aided teachers to a particular dates. That amounts to violations of Rule 9 of 74 rules. And in that respect, my lords, the law has been settled by the Honorable Court in case of Dittira, in case of Judicial Katua, in case of so many cases, my lord, law has been settled. Only the issue is Rule 9. You also kindly see Rule 9. Lots must have gone through Rule 9. So for the pay and DA, that should be at par with the governments. And while giving the benefit to the aided teachers, now they are giving it notionally with effect from a particular dates and financial benefit with a particular dates. Whereas to the government teachers, they are giving it with effect from 1/1/2016.
Not notionally.
Not notionally. From the very beginning they are getting.
To you people, it is made notional.
It is made notional by particular date and thereafter regulars.
Any representation you had given?
No, representation in some cases also disposed of. Now they have that not been considered. That matter requires adjudication. I pray also issue notice.
Yes.
The law is settled in this case.
Issue emergent notice. Learned DGA Mr. Lenka accepts notice for the respondents. Pleadings to be completed within 8 weeks. Okay.
Item 19.
And case, my lord. Petitioner challenging the order passed by the opposite party, chairman from collector, my lord, 3, my lord. Kindly glance Annexure 6, my lord. Here, my lord, the opposite party not consider my qualification for the selection of the PET, my lord, physical education instructor, my lord. Kindly glance Annexure 6, my lord. The second row litigation, my lord. Earlier, this court direct to the opposite party dispose my representation. Kindly glance Annexure 6, page 29, my lord. The last portion, my lord.
Deepak Kumar Kathua.
My lord. Here, my lord, the last para, last second, my lord. Whereas an advertisement so and so publish inviting application for engagement of part-time instructor performing arts, fine arts, and physical education under Sarva Shiksha Abhiyan Cuttack. Now, Samagra Shiksha Cuttack, such advertisement had a categorical stipulation as regard to eligibility of the engagement.
Yes, but what is?
No.
Requires examination.
Yes.
Issue emergent notice. Same order. Pleadings to be completed. Sides.
My lord, I have filed an interim application. Earlier, this court could not branch granting the interim matter. One post kept vacant, my lord. Already mentioned my order, my lord, Annex 5, my lord. Last, this could not branch disposed my representation, stating that the earlier order, which has been 2017, my lord, the one post kept vacant, my lord. That is
Since 2017, that post is kept vacant
my lord.
for all these years.
My lord, interim order still continue, my lord.
Okay, the board.
Can I glass Annex 5, my lord, for clarification, your lordship. The last portion, my lord, the interim order earlier granted should be continued till disposal.
Learned counsel for the petitioner draws attention of the court to the coordinate bench order number 65, 5,
My lord.
dated 2/12/2024,
My lord.
wherein a post was directed to be kept vacant. And therefore, in this case also, similar interim protection should be granted. First, there is force in this submission. Next paragraph. In the above circumstances, the jurisdictional OPs are directed to keep one post unfilled during the pendency of petition. First, if there is a high urgency of filling, it shall be okay. If anybody is filled up, subject to result of this list pendants, I have made it.
So that, my lord, because OP3 is Kotak, my lord, since 2017, my lord, pending. And similar,
Yes, I have said that.
my lord.
I have protected your interest, not to fill up. If at all to be filled up, it should be list pendant, subject to outcome of the petition. Okay.
20 says.
Item 20
20 also same, my lord.
in this submission.
20
also same.
Same, my lord.
Call along with each other. Same. Yes.
Item 21.
May I please? Matter regarding regularizing my suspension period for the grant of pension and any other retirement benefit.
No disciplinary inquiry was conducted,
Also completed, Your Lordship.
completed,
My lord.
and you came out without any blemish.
Without any premises, Your Lordship, that the criminal case also acquitted.
You gave the representation.
Your Lordship, this is the second
25
May.
Page 54, your lordship, page 50.
5-4.
Yes. The
Running page 53, Your Lordship.
53 last. Whereas after careful consideration of the charge framed against Sri Patra, finding of the inquiring officer and the representation of Patra, the disciplinary authority has been pleased to drop the proceeding initiated against Sri Gangadhar Patra, retired assistant teacher, with the following conclusion. Pay of Sri Patra shall be fixed in the scale prescribed for an untrained teacher as he fails to produce CT training. 2.
What is that city?
Certified teachers training. That is. Then period of suspension of Sri Gangadhar Patra shall be regularized for pension purpose only. Minimum pension prescribed under ORSP rules 2017 shall be granted with immediate effect, and other retirement benefits shall be released on consultation and approval of a higher authority. Other retirement benefits prescribed for trained metric teacher shall be considered on receipt of certified training teacher certificate from Sri Patra.
That's a must for that getting that salary.
No, he has now already retired.
No, he has retired.
Yes. Yes.
Suppose if he had not been suspended,
Yes.
how much he would have got?
That this is the order they have passed.
No, that's
I need to
therefore he is here.
Yes.
The order is passed is true. Question is, had he not been suspended, what he would have got, that he should get. Because you dropped the inquiry proceeding.
Yes.
Then how can you be prejudiced?
Then the period of suspension period would have been treated as a duty. That's no.
Yeah. Because he is not at fault.
Yes.
You prevented him from working.
That is there. That is there. We'll file the counter.
All right. Issue emergent note. Same date is sent. All right.
So that Your Lordship, the 3 doctors
It will come.
in touch here.
Date fix. All right. Item 22.
My lord, petitioner's prayer is for regularization, my lord. He is working as peon in Madhusudan Law University, my lord.
How long?
My lord, from 2008, my lord. From October
2008?
Yes, my lord. My lord, on Friday on 22nd of August, the Lordship has issued notice in similar case.
Similar matters notice is issued.
Yes, my lord.
Issue emergent notice. State is also party.
Yes, my lord. State is.
Why state is party if university is functioning?
Because, my lord, it comes under the aegis of Higher Education Department, my lord.
ASC appears for 1 and 2. 1 and 2. Emergent notice to the rest.
My lord, interim order, my lord.
What interim order?
My lord, because they will terminate, the termination is the apprehension of the petitioner, my lord. Your lordship in that case also has granted interim order to.
No, it all depends. You know, where have you mentioned there is threat of.
My lord, in IN number 13848 of 2025, my lord. Flag A.
What you are saying?
Para 5, my lord, I have mentioned that the petitioner apprehends that the opposite party has made took coercive action against him because of filing of the present writ petition.
What is coercive action meaning?
My lord, either they will terminate him or they will
That is not coercive action.
Or they will not pay him the salary, my lord.
Good. Learned counsel points out the accompanying application supported by an affidavit where he apprehends some prejudicial action at the hands of the university because of he approaching this court, and therefore he be protected. First off, he is trying to be protected. First off. Learned counsel also tells that in similar matters, such a protection has been afforded by this court. Why the WP number?
My lord, WPC number, that is WPC number 23080 of 2025.
23080 of 2025. First of all, there is force in this sufficient. Prima facie force in this sufficient. First of all, next paragraph. In the whole circumstances, the interim relief granted in the cognate petition is extended to the petitioner, subject to same terms and conditions. Item 23.
May I please?
Yes.
In this case, the petitioner challenges the initiation of proceeding under the Rule 23, that is Orissa Scheduled Caste, Scheduled Tribe, and Backward Castes Regulation 23, my lord, for cancellation to file show cause, why your caste certificate shall not be cancelled, my lord.
They have issued the show cause.
Show cause. My lord, but no inquiry has been made without making any.
Now you tell that also. You have sent me show cause notice. I am replying you like this. You should have held inquiry. Then you should have done this exercise. Therefore, recall the notice.
My lord, actually the inquiry was made for my brother, and that order has been said. That proceeding of my brother has been stayed by this honorable court because no inquiry has been made. Or
you tell that in your reply.
Once we will file the reply, they are passing the final order and
no, you come before the court.
My lord,
immediately we will grant some interim order if it is worthy.
Sorry, my lord.
When Apex Court say,
yes,
if show cause notice is issued by the competent authority,
my lord,
the citizen should show the cause.
My lord.
And he can request to recall the show cause notice because of A, B, C, D grounds. We'll give you some time to file that.
Date is fixed to 3rd of September, my lord.
3rd September.
My lord.
We will give some more time to file reply. All right.
My lord.
Okay.
Until then, not to pass any final order.
Till reply is filed and considered. All right. Petitioner is knocking at the doors of his court for assailing the show cause notice dated
11/4/25.
11/4/2025. A copy whereof avails at Annexure 3 series.
My lord. cause with the show cause notice, some documents they have given.
Annexure 3 series. Wherein he has asked to show cause as to why he's is it a scheduled tribe status? Scheduled caste or scheduled tribe? Scheduled tribe certificate should not be withdrawn. First one. Next paragraph. Learned counsel for the petitioner argues that such a notice could not have been given without holding a preliminary inquiry as required under the subject rules, extant rules, and therefore the same is liable to be voided. First one. Next paragraph. Learned ASC appearing for the OPs resists the petitioner, contending that ordinarily writ courts would not interfere when show cause notice is issued, inasmuch as caution can be shown against the proposed action by the noticee. Noticee. First one. There is a force in this submission. First one. Next paragraph. In the above circumstances, the petition is disposed of, giving a period of 4 weeks.
Last week of September by the last.
Giving a period of 5 weeks for filing the reply to the subject show cause notice 7. Till the reply is accordingly filed and the decision thereon is taken. And also a week expires after the communication of the said decision, comma, no adverse action shall be taken against the petitioner. We have given 1 more week after the decision. So that you can approach whichever court you want to. All contentions of the parties are kept open.
Can I show one thing? Annexure 4, my brother's case has been stayed by this Hon'Ble Court.
That's all right. We can make same order the next time when your daughter's case comes. Yeah.
Item 24.
You are fully protected because not only till decision is made, 1 week they will not give effect to any to said decision, if at all it is adverse. Okay.
In this case, petitioner challenged the order of rejection under Annexure 17, where the regularization of the case of the petitioner has been rejected. He is appointed through selection process since 2013 on contractual basis. Number of decisions has been made in the meantime by the Apex Court, but the case has been rejected, page 91.
91.
The
what's ground?
Ground that he is appointed on contractual basis. Page 91, last Sri Sanjay Kumar was engaged as librarian on contractual basis on consultative remuneration, filed letter director of ST development. He joined as such in the said post on C4 to then he is continuing against the said post till date without any bag. No, to contractual or regular librarian post has been created for Government BD Training College, Kalinga, Kandhamar. The contract was made for the post of librarian in Government BD Training College, Kalinga, Kandhamar through walk-in interview. By selection process, by advertisement, out of 25 candidates, the petitioner has been selected. Consular examination has been made by the following recruitment procedure, but not against the corresponding regular posts. And post of librarian goes to B category. Earlier he has approached before this Hon'Ble Court and
directed consideration, they have considered and this is perfect.
The petitioner has been engaged through a selection process.
That's what, that was for contractual employment. The contract has come to an end, therefore we
no, not end. Not end, my friend. I am claiming for regularization.
Where is that regularization, right to regularization, when it is a contractual post? Which rule says you will be entitled to regularization, even when your appointment is term appointment on contract?
The 2000.
Which rule?
Annexure 12 is a contractual rule, sir.
Annexure
Does
12,
it
page
provide
70.
for regularization?
Sir?
Does it provide for regularization? No.
No, my lord.
Yeah.
That is not for regulations, my lord.
Where is your right to regularization? When you are appointed for a particular term under a contract,
Sir,
contract is discharged and you will go.
means all the contractual appointment will be regularized after in 2020 has been repealed. That rule has been repealed and all the contractual appointment will be regularized. That I have not enclosed, my lord. That
Then how you will? I will know. If you keep it in your pocket, how I can put my hand into your pocket.
and Madam Annexure 20, the principal also faced Annexure 20, page 104 for consolidation remuneration and for creation of the post has been made to the government. Annexure 19, page 94.
Who has principal has recommended?
Recommended.
Issue emergent notice. The government is asked by the principal, post is very important. Create one post, otherwise our institution will suffer. Even then, government will not take decision.
Regular post will fill up by the PA will conducted by the
No, post itself is not created.
PS ballot.
Huh?
It's a public service will conduct the
Provided the post is available. There is a request for creation of the post. Should you not look into that, at least when principal saying, not some puny saying, kindly create a post and give me their job. The principal of the institution is saying, the institution will suffer without library. This country is known for libraries. Is it not? There were 23 libraries in the bygone years, bygone centuries. And many of them were burnt. Takshila, Nalanda, Utkala, is it not? Mithila, so many universities. Now he's saying there is no librarian at all. Would create one post so that library will be maintained. Even such things also will not be looked into by the government. Issue emergent notice. Learned ASC is requested to accept notice for the OPs. Notice to college also.
No, sir.
You will accept notice for college also.
College.
for all the opportunities.
All the people.
Dr. Ambedkar said in one of his speeches in Bhandarkar Institute, he advised people that whenever you construct a house, whether you erect a puja room or not, build a library in every house. It's great advice because library is so much important. Is it not? Yes. Do you go to High Court library?
Yes, ma'am.
You spend time there. Have you gone to High Court library?
Yes, yes.
Ah,
Sir, I find one I.
for
Enhancement of resources, sir, since 2013, the petitioner is getting only 12,000 only per month. But there is a amended rule 2000.
But how interim order can be granted?
Sir, that I am showing, sir. Annexures 14, page 79. Sir, already that amended, that consolidated remuneration will be enhanced with effect from 1/1/2016. Next page, page 80. But that has not been granted.
Let us see.
Sir.
Issue notice on both merits and this ASC accepts notice. Okay. Item 28.
I pray for Lordship's indulgence to permit me
26 and 27.
to permit
Your Lordship's judgment delivered today. So review is not maintainable.
Lordships, wrongly in the cost title, it is stated that the state of Odisha is the petitioner, but it is reverse. I am the private party is the petitioner. So therefore, Lordship, kindly grant me liberty for 1 day time. By tomorrow, I'll file the amendment application.
Because Lordship's review is to be filed by the opposite party. The state succeeded in the FO.
No, where is the review maintainable?
Lordships, only that is a wrong cause title. Let me make the correction of the cause title and the everything.
It is not review.
No, review by opposite party.
State.
But it is not by state. Cause title, Lordships, kindly see in cause title, it is written the state of Odisha as a petitioner.
No, that's all right. I will allow you to rectify that. But essentially, this is a review petition.
Essentially, this is a review petition.
Review, I have held that review is not maintainable.
Lordship, let me make the correction, Lordship. Thereafter, Lordship, whatever the order passed, Lordship, let me make the correction, Lordship.
What correction?
Because I am the private party.
I will make it. I will make it.
In the recitals also.
Also, I will make it that this review is by you, not by the state.
By the state.
You need not amend. We accept your oral submission itself now.
Then in the prayer also some correction that is written at opposite party.
Essentially, these are all review petition, regardless of wrong description of parties in the cause title. First one, the cause title mentions that the state is the review petitioner when it is the private party. First one. That makes no difference to the substance of the matter.
Only I pray, Lordship.
The counsel for the petitioner submits that some correction needs to be made in the prayer column also. First off, even that does not make any difference in view of the decision of this court pronounced this day in review petition number so and so, specifically holding no review power is vested in this court. First off, next one, in the above circumstances, this petition is liable to be rejected with liberty to the petitioner to work out his remedy elsewhere in accordance with law. Next, all the same order.
Lordship, only I pray, let me check whether this is covered or not covered. Let me check.
I have read the papers, then I am telling.
Lordship, this is the order. If it is pursuant to this order, then
which is that order?
Which I am challenging, Lordship.
No, this order is by this court only.
This order I have challenged.
This order by this court.
By this court.
Therefore dismissed. I'll take this. Okay. Next. 26, 27, same orders. Yes.
Item 28.
Lordship, in view of the earlier judgment passed by this honorable court.
In view of today's judgment, some research I have made relating to
but
review.
I did not get opportunity to make the research.
Go through that. You go through that. If you are not convinced, then you...
Here also liberty granted to file review.
No, that makes no difference. By liberty, we can't invest review power in the court. It's a statutory requirement.
Lordship, because nobody was present at that time, the order which was passed on that day, non-appears for the parties. Whether that order was brought to my Lord's knowledge, I didn't know.
I have
I did not
20 pages
judgment.
And that not only I don't depend upon only the material furnished by this bar.
That's it.
Because I don't have that great opinion about this bar. I tell you, I confess that. I should tell this. I can't resist myself from telling this. So far as intellectual height of this bar is concerned and research skills are concerned, there is lot of scope for improvement. I am putting it very clearly. Okay.
By down, we are lacking also. We are lacking that.
No research takes place. No research takes place. No books are brought to the court. No maxims are cited. No great works are cited. No, at times, no law is cited.
Lordship, then kindly give me to 7 days time so that I
no time will be
apprise
granted. We have given that judgment, and you can test my judgment elsewhere. Okay, next.
This case, my lord, your lordship was directed to take instruction. I am not getting salary.
Your
Central government.
salary.
My lord,
Yes.
my lord, I have received an instruction 2 days before. They need some more. They are asking for some documents.
Salary is not given from how long it has not been?
Since April, my lord, I'm not.
Since April it is not given. Then how he should hold his body and soul together? Have you got family? Have you got family?
Yes, ma'am.
This is university.
It is university. They are actually, they are the central government. University has given the budget to pay, and I am working. And they have to, your lordship was directing them.
Even when working, you do not pay the salary.
I was sought my instruction. They have written a letter, my lord. They need some time, my lord. I'll get an instruction, my lord.
When will you?
Any date, my lord.
Call this matter on 2nd of September. Let the request of Learned Counsel appearing for
OP number 2, my lord.
OP number 2. First time. Okay.
Item 29.
Item 29.
Yes.
I filed an I for intervention in petition. With my promotional appointment is affected due to the interim order passed by this honorable court in first case, my lord.
This is after notice.
My lord.
All admission matters are over now. After notice are also for orders.
For orders, I filed an I for intervention. For the
Already in this case, I am appealing for the petition on my.
Yeah.
My grievance before my lord that pursuant to a notification, I applied for the post. On being selected, appointment order issued in my favor. Containing terms and conditions, my lord. Annex 3 is my order of appointment. During my continuance in the deputation post, the lending organization, my lord, issued an order for my premature repatriation, my lord, not by the borrowing department. So I approached my lord. I am protected with para 10 of OM dated 17th June 2010, my lord.
You are appointed as what? You are appointed as
I was appointed as Assistant Administrative Officer.
Assistant Administrative Officer. When?
Order of appointment is dated 26 December 2022, my lord.
26/12/2022. All.
For 3 years, my lord.
For 3 years.
My lord.
It's a contractual appointment.
No, on deputation, my lord.
You are on deputation.
Deputation, my lord.
Your original post parent department is what?
Central University, my lord.
Central University.
Central University, Courtroom.
Now you are agreed by what?
I am agreed by Annex 7, my lord.
What it says?
For premature reversion, my lord, to my parent department. And that letter order issued by my parent department, not by the borrowing department, my lord.
Parent department called you back.
Parent department called me back.
Now you go back.
No.
Why?
Because I am protected with the OM. OM dated 17th June 2022, my lord.
17 June 20.
10, my lord. Annexure. 11 starts from page 39. Your lordship kindly give a glance. Para 9, page 48 of my writ petition, my lord.
Read that.
Normally, when an employee is appointed on deputation/foreign service, his services are placed at the disposal of the parent ministry/department at the end of the tenure. Full stop. However, as and when a situation arises for premature reversion to the parent cadre of the deputation, his service could be so returned after giving an advance notice of at least 3 months to the lending ministry/department and the employee concerned. In this case, my lord, borrowing department has no objection for my continuance. Notice are not given by the borrowing department.
No, question is not borrowing department has no objection. Question is whether borrowing objection objected to your premature repatriation.
Yes, my lord.
Where did they say?
They have filed their objection and accordingly also grant me interim order, my lord.
And no notice was issued to you.
Yes, my lord, they have already received notice, but they are not filing counter till today.
No, notice to you saying that we want to send you back.
No.
We want to
Yes,
recall.
my lord, that is
My department has not issued any notice to me.
Your parent department has not noticed any issued notice to you.
Parent, in response to parent department notice, borrowing department has not taken any action or not issued any notice to me till date, my lord.
Go to page 40, which you referred to. Page 40.
Page 48.
These orders shall it take effect, so which paragraph normally when an employee is appointed on nation foreign service, his services are posted at the disposal of the parent ministry or department at the end of the tenure. Correct. However, as and when situation arises for premature reversion to the parent cadre of the deputationist, these services could be so returned after giving an advance notice of at least 3 months to the lending ministry, bar department, and the
employee concerned.
No, this duty, kindly see that. Notice need not be given by the lending ministry, your parent department at all. Notice has to be given by borrowing department if it wants to send you back.
My lord.
It is not sending you back.
No.
They are calling you.
They are calling me.
This is not applicable. Read it.
My lord. But in the meantime, my lord, as per my instruction, Annexure 7 has already recalled.
Annexure 7 is?
That premature reversion notice.
That is recalled now.
Yes, as per yesterday night, I got information from my clerk.
From your clerk?
Client, my lord. The party. From the petitioner.
From the petitioner.
Well, so your lordship grant me 1 week time. I can file that along with an additional affidavit.
No, the question is not that. Question is, the parent department, you belong to parent department. Your lien is there.
Right.
They want you back. They are calling you. You should go back.
So, my lord, during mid-session or during halfway of my deputation, I am not.
What is your right to remain on deputation?
Because I
They cannot send you back without giving notice to you. You are giving notice to the parent department. That is the text. So, for parents' power to recall you back,
my lord,
is inherent. You are his servant.
There is no such provision available, my lord.
Supreme Court has said this.
But I am for the university. I am for the parent department. The parent department has considered its deputation as a letter to all these petitioners.
Allow this petitioner to continue.
Reconsideration of premature reversion of the poor employees, Central University Odisha, deputed to AIMS Bhubaneswar.
What is that?
With reference to your above cited letter regarding reconsideration of premature reversion from deputation of poor employees to Central University, this is to inform you that the competent authority has reconsidered the decision of the premature reversion from deputation of following employees and allow them to continue their deputation.
Then petition has become post it and this one. Then how, what your application? That question does not arise.
No, my question is that my emotional avenue has been affected due to the interim order passed by this honorable court because he has no right because the no service condition has been violated. In each case, he is deported to his parent post. But my kindly peruse annexures page 7. Page 7.
Take out
7.
1 second. Without preparation coming and again interrupt. Take out HP Lakshmi Narayana versus KFDC by Justice Sridhar Rao. Maybe in 2000, something like that, I do not remember. Where Karnataka High Court held, where promotional avenues do avail, then bringing people on deputation is not permissible because that will affect right of promotion of these people. Is it available? HP. Yes. HP Lakshmi Narayana versus Karnataka Forest Development Corporation, 16 October 2000. You just look into for your purpose. But this petition has become infructuous because they have already granted relief to him.
Yes.
You look into that. Without looking that, you should not do. You should be all your rulings and everything should be on the tip of your, not only tongue, on your fingers. That is advocacy. That is advocacy. Anything less than that is not advocacy. It is drama. It is celebration of ignorance. Yes. The petitioner has called in question the order dated 24/7, which is that order by which you evaluate
24/7/24, Annex 7.
24/7/24,
Page 20.
whereby his deputation period having been cut short, he was recalled to the parent department. First time. Give one copy to friends. Next paragraph. After service of notice, learned counsel appearing for the parent department of the petitioner places on record the letter dated 26/3/2025 issued by the University, Central University of Odisha, Koraput, to the effect that the impugned order of repatriation is recalled and petitioner is permitted to continue on deputation. First time. Next paragraph. In view of the above, the petition has become infructuous, the relief itself having been granted by the parent department of the petitioner. Petition is accordingly disposed of, all applications failing to insignificance. First, in your matter, you press into service that judgment.
I beg your pardon.
Yes.
I am for the Ames, opposite party number, that is the borrowing department.
Borrowing.
Yes, opposite party number 3 in last 2 cases. Connected 2 cases, so my appearance will be.
I am for
See, that got to be shown as a page.
last 2 item, I am from OP3.
2122 and
How
2163.
that it should be all that.
Page 7 of my introduction. Only read this one. But I'm not. Only page 7 of my individual petition. Why not they giving? And I had to inform that your application on the subject matter has not been considered by the competent authority for the timing, as the vacancy for promotion to the post of AAO is temporarily unavailable as the position is already occupied by the petitioner through deputation, and his repatriation has been stayed by the Hon'Ble High Court of Orissa.
Then how is a separate cause of action? How can you maintain your intervening application in this? Yes. Next. Item 30. Yes, sir. All 3 same writ petitions.
Yes.
Yes, board.
The first 2 item, I am for OP3.
Yeah.
Item 30 is that execution of the orders of the Supreme Court.
Yes.
Order 45.
Order 45, Rule 50.
Only I pray you not should take up after lunch.
After lunch?
Yes.
All right. Are you offering lunch to him also?
He never offers.
Okay. Awesome. Item 31.
May I please, Your Lordship, I am on busy, my lord.
But even you asked for time, no?
Yes, my lord. For filing the
Filed by the petitioner for the self-same relief before the civil court. So in view of the fact that for the same relief, the suit has already been filed, writ application cannot be entertained.
How writ petition is maintainable when you are seeking relief before the civil court? That's what the senior counsel Mishra is asking here. What's your answer?
Your Lordship, I need some time because I haven't prepared anything right now, but I need some time, my lord. That's why I asked for time. Just matter has today I have just assigned with it.
On this matter.
Right.
3rd September. Okay.
Interim order to continue, my lord.
You want to continue?
So that is the reason that they couldn't get the interim order. They got the
Therefore, you have
interim order.
filed it. Okay. For my comments may not be mistaken. They are only clinical comments. My comments that I don't have great opinion about this bar should not be misconstrued. It is only a clinical expression of the opinion because I treat the bar with respect. I want the members of the bar to be fully prepared.
Right.
Subject to some exceptions. Where is
Right,
the
absolutely
question?
correct. All the courts should expect that.
I don't go home with jubilance at all.
Right.
I don't go home. You should make me go home with value addition.
Right.
By your arguments, I should go and report to my people at the home that I learned so much from the argument at the bar today that I have never felt, barring 1 or 2 occasions.
So with your lordship's presence, the bar will definitely improve.
I want that assurance.
Right.
Bench also should improve is another thing.
Right.
There is improvement for scope for improvement in heaven, said Oscar Wilde. The Oscar Wilde, who was convicted for the offense of sodomy and placed in the jail, where he wrote certain poems on the jail wall, which became part of one judgment by the Supreme Court, bail or jail. If bail is ruled, jail is an exception. It was inspired by Oscar Wilde's writing on the jail wall.
Right.
He said, there is scope for improvement even in heaven. If that is so, there is scope for improvement at this side, at that side also.
Correct.
Both sides. Only knowledge generates wealth. See, Adam Smith, Wealth of the Nations. He says, the knowledge generates wealth. It is true.
That's right.
Yes.
Item 32. Item 32.
My lord, an item, sub-item 4, my lord.
Sub-item 4. What are these matters?
Yes.
Yes, start. 2018 matter.
Which is my case first. My lord, the petitioner was an allottee of LIC of a residential flat made by LIC. There are 400 some odd flats were built by LIC. 345 flats were sold out. When my term came, LIC said,
what is that LIC? Life Insurance of India.
LIC said, the record of right is not in our name, so it will take some time. If you want to take back your advance money, you can take or wait. I prefer to wait, not to take back my money. Subsequently, the ROR stood in name of LIC. Now they are selling out the property to different people on auction. As in my case, there is an interim order. My flat has been reserved. It has not been sold out. So that record of right.
What scheme they assured you that they would sell the plot to me?
Through lottery.
Where is that scheme?
Lordship, Annexure 1.
What one is that one?
The very relevant annexure will be annexure 4, my lord.
For
Annexure 4 will also be see. Just last but one paragraph. We have therefore applied. Starts with. We have therefore applied for record of right to Tahsildar Bhubaneswar on 29/5/2014. It is understood that to get the record of rights, it takes considerable time. Therefore, we have decided not to receive any payment from allottees till we obtain the record of right, and last date for receiving the payable amount shall be extended. The last date of receiving the payment shall be intimated to you after receiving record of right. So subsequently, I replied,
who appears for the LIC?
I am appearing, my lord.
What do you say?
For time, my lord, my senior is out of station, my lord.
2018 matter.
Yes, my lord.
What is that? You told them that after record of rights are updated, we will give you.
Yes.
And now they are updated.
Now, my lord. Today, I am filed the additional update filed by the petition reply, my lord.
Keep all that. That is not the question.
Yes.
You received their money
Yes.
for granting of plots. And then you said, no, in respect of these plots, our name is not entered in the ROR. Therefore, you take back money.
Yes.
And after our record of rights reflect our name, we will consider your claim. That is the letter which your Deputy Chief Engineer has written on 12/6/2014.
Yes, ma'am.
And now the record of rights are updated in your name.
Annexure 6 page 40, my lord.
Annexure
6 page 40, my lord.
What is that?
You would like to inform
cancelled it.
Cancellation of flat, my lord.
On what exactly?
On the ground that the record of rights did not contain your name.
Yes, my lord.
And now it contains. You are not a businessman.
No.
Read LIC of India versus Escorts Limited, AR 1986 Supreme Court. You are not a businessman. You are a statutory body. Is it not? Therefore, you have made an assurance to the people. Yes, we are giving you the plot. You give advance of rupees 1 lakh. And they gave it. Then you said, your wrong word, it is cancelled. Allotment, where did you allot? You are not allotted at all.
No, that was not for 1 lakh. 1 lakh was advance. 1 lakh was just advance one.
Advance, no executed, executed, my lord.
Correct. But you have held to the public at large that we are allotting these sites.
Yes, ma'am. The allotment letter was issued.
Yes.
And subsequently NOC was issued.
Issued. Then cancelled. It did not stand in the name of the LIC.
What happened now? They are selling it
To others.
through auction.
They have collected all these things. Subsequently, they are selling through auction.
Through auction.
But here we are protected through entry model. No third party interest.
Just 1 week time, my lord. From Monday.
Read Union of India versus Afghan agencies. And Padampat Sugar Mills versus Union of State of MP. And read Palkiwala's affidavit, which was filed in the American court in relation to Bhopal disaster case. In Upendra Bakshis mass disaster and law, the affidavits are produced as annexures. Mr. Palkiwala told to the American court, because the argument of Union Carbide, the Bhopal gas disaster, the company says Indian courts are not of that high order, but American courts are. Therefore, American court should decide the claim. Then Union government got Palkiwala's affidavit filed and J.B. Dadachanchi's affidavit filed, wherein they highlighted Motilal Padampat Sugar Mills versus State of MP, saying, in our legal system, both the legitimate expectation and the estoppel are available to the citizens, not only as a shield, but as sword. On that ground, American court sent that matter back to Indian court. So that is the greatness of promissory estoppel in our system. This is a kind of promissory estoppel. No, having taken money and you're asking them, no, take back your money, we want to do business. How are you going to do business? Well, I'm allowing the petitions now.
Paper just to paper Monday, my lord.
You want time to prepare?
Yes, ma'am.
Okay. Matter reluctantly adjourned to 9. At the request of learned panel counsel appearing for the LIC. There are many judgments on which celebrate the doctrine of promissory estoppel. There is one judgment of US Supreme Court by Justice Felix Frankfurter, which is referred in 2 judgments of the Apex Court. One is B.S. Minas versus Institute of Statistical Institute. Another is International Airport Authority versus Ramakrishna R.D. Shetty, with Raman Dayaram Shetty. They have referred to American judgment of Felix Frankfurter. All they run counter to your stand before the court. Okay? Just look into, prepare a small note of what all I have said and bring it. Whoever will bring it, he will have 5 extra marks. Yes. What is meant by 5 extra marks? I don't know. Certainly, it is not an order.
Interim order to nothing.
Interim order till next date of hearing.
Extension of
33, my lords, it requests counter, my lords.
33.
My lords.
Which year?
23 of the year
23.
My lords.
2 years you are not filed counter.
My lords, I beg apology, but it is required. The lordship may grant for 3 weeks' time, will file counter.
We'll give 2 weeks' time in that we will file that counter. Finally, and very reluctantly, a period of 2 weeks is granted to file the counter to the petition. First, if not filed, the petition averments may be taken with face value. Call after 4 weeks. Next, item 34.
May I please, your lordship?
Yes.
Well, at the last occasion it was heard by your lordship extensively. The matter is, my lord, the petitioner was appointed in the school for the blind as an attendant, female attendant, my lord. After the death of her husband, who was serving as a attendant since 2009, my lord. Thereafter, my lord,
What is your prayer?
My lord, prayer for objection against the vacant post in which I am continuing, my lord.
Approval to absorption.
My lord.
Absorption and approval.
My lord. My lord, I am continuing that post on consolidated salary, my lord. Annexure 3, page 12, your lordship may see. The government is wrote letter to the all special schools. My lord, my school is the school.
1 second. You joined service when?
My lord, after my husband's death, 2022, I joined.
As on compassionate ground.
My lord, yes, authority has decided and given a
compassionate appointment.
My lord.
Dated
25/1/2022. My husband was.
1 second. 1 second. 25/1/22.
My lord.
You were appointed as?
Attendant, my lord. Cook, attendant. My lord,
Who appointed you?
the management, my lord. My lord,
Management of?
management of the school for blind. This is a special school
Okay.
under the DS Social Security Welfare Department, my lord. Social Security and Empowerment of Persons with Disability Department.
For differently abled children.
My lord.
And getting aid also.
My lord.
Aided school.
My lord. Your lordship, Annex 3, page 12.
Aided school or government school?
My lord, the government is granting the
Granting aid is granted.
My lord. Annex 3, page 12, your lordship may see. In that post, my husband was serving since 2009, my lord. And he was died on heart attack on 23/8/2021. 23/8/21. And they have also admitted in their counter that aspect. My lord, Annex 3, page 12, the District Social Security Officer, Baleswar, page 12, your lordship may see, to the chief functionaries of all special schools to furnish the list of the employees for their selection, for their absorption, my lord. Page 12, my lord.
Page 12.
My lord. In a format. The lordship got it, my lord?
Yes.
This is the format, my lord. In pursuance to the government's notification that is there. But my lord, your lordship, my authority, my school authority has annexed 5, your lordship, page 14. Has furnished the information pursuant to that letter, page 14. And my name is in the attendant, Bonita Behra is there, and other staff's name is there. Page 14. Thereafter, your lordship may see page 15, the district authority has given, listed the names of the employees, page 15, and my name is at the serial number 5, Bonita Behra. And that everything has been in the remark column, it was the experience, everything has been written, my lord. Thereafter, the document verification, page 17. Annexure 6, page 17, the document verification they have issued that you appear and with self-attested copies and for verification. My lord, thereafter, my lord, Annexure 7, the selection committee has decided to held on meeting for absorption for regulation on 4/7/2023. My lord, the Annexure 9 is the proceedings of the meeting, page 20. Your lordship, there
were 8 special schools.
My lord, the second serial number 2, page 20, serial number 2. In my school, the sanctioned posts are headmaster, assistant teacher, interpreter, and attendant F, in which I am continuing. That is the only sanction existing vacant post. I am continuing. My lord,
1 second. This is in respect of 2 schools, 3 schools.
8 schools, my lord.
8.
More school. My school is serial number 2.
Yes, you are right. Your number?
My lord, attendant. That is the post sanction post they have written. Attendant, the third column, my lord. Third column. Headmaster, principal, headmaster, assistant teacher, trainer, trained intermediate, then attendant. Your lordship got it?
Attendant female.
My lord, I am the female attendant and continuing in that post. And the other schools are there. Thereafter, your lordship may see page 22. In the same document, page 22. They have recommended these 12 persons.
That you possess requisite qualification.
No, I have possesses. They have stated that since you are not having 5 years experience, that is why your case cannot be considered. That is the only reason they have been the counter. And that 5 years experience was put by them, not by the government. Government has stated that in the school, you keep one attendant, experience holder, requisite qualification, not 5 years. And my contention, my husband was serving in 2009.
Otherwise also that condition will not apply to a case of compassionate appointment.
My lord. And your lordship, on the last occasion that only my brother was taken time, your lordship about to dictate that order. That is why part of matter why your lordship. That your lordship, that condition is not there.
And who has put that condition?
The DSSO, my lord. The committee has decided that we will consider the cases only those who have 5 years experience. So my condition, my husband was serving since 2009
and she was died in 2021 in heart attack. Thereafter, considering as a widow lady, and I am also a requisite qualification to hold the post of attendant. And the government has stated that in the school of blind, the female attendant should be posted. And against that sanction post, as I show your lordship page 20, that is a sanction vacant post, I am continuing. The case of others has been considered, whereas my case on the ground that, my lord, that was not considered. That only.
This is for granting aid.
My lord.
Approval is for what purpose?
My lord, the school is, my lord, the special school running by the different agencies, and they are getting the grant from the government, and the school is running, my lord.
Correct. But you are employed there.
My lord, I am by management with a consolidated salary of 2,000. I am continuing.
So regular salary is not being paid.
Not paid.
Because post is not subject to grant in aid.
Post has a grant in aid, my lord.
Post is grant in aid. But to the appointee, they have not given the approval.
Because
they have not given the approval.
No, my husband has given approval.
No, that's all right. Husband was employed. He died in 21 because of heart attack. You said that twice now.
My lord, until unless the post will be approved, then I will not get the grant in aid.
Post will be approved or appointment will be approved.
My lord,
that is already approved now. Attendant female.
My lord, that is sanction post is there.
Correct.
My appointment is to be approved, so that I will eligible.
Which rule requires approval by the government? Which is that rule?
My lord, that the government has stated, my lord, there isn't.
Yes, brother, why?
My lords, my first submission is that it is not a case of compassionate appointment.
It is not a case of compassionate appointment.
Rehabilitation assistant rule is not applicable to this.
But it was given appointment because husband died in 21 because of heart attack.
It was given by the erstwhile management. That management is no more in existence. And she was called to submit the documents.
Yes.
And my lords, kindly see the rules.
She submitted.
My lords, no, my lords. My lords, kindly turn to page 35, my lords. The rules guidelines governs the field, my lord.
35.
35. 11. Appointment of staffs in the institution. My lords.
Who has issued this?
This is made by the government. My lords, page 24. The Act.
Page 24 of
my lord, so page 24 of my counter. Guidelines for establishment, recognition, and granting aid to the institution impairing education to children with disabilities, my lords.
24.
My lord. These institutions are governed by these guidelines, my lords.
Where are the guidelines?
This is the
guidelines. The guideline is page 13 of that counter. They have stated.
1.3.
1.3 of that counter.
Go to 1.3.
Page annexer B/4.
My lords, page 24. Resolution dated 6/6/2022.
Page 13.
1.3.
But on 3 of their counter, that is the filling of the vacancies in the special school. That is para 2. They have stated that.
One second. Do not disturb the government advocate. I'll hear you.
Yeah. Sorry.
Yes, sir.
My lords, this is this in order to fulfill mandates of Right to Education Act 2009 and Rights of Persons with a Disability Act 2016.
Where are
government,
you?
My lords, page 24.
Page 24, it's not that, it's affidavit.
My lords, page 24 of my counter.
24 of the pages, we are not on the same page.
Well, sorry, my lords. This is counter filed by opposite party number 3 and 4.
Yes, 3 and 4.
Your Lordship got it.
24 I got, but it's an affidavit. Affidavit perhaps supporting the counter. Is it?
No, my lord, this is annexer H.
Annexer H. H, C. Right, forget that. Annexer H, resolution.
My lord. My lords, here kindly turn to page 35.
Annexer H.
H starts at page 24.
At 47.
55, my lords.
Your counter begins at page 24.
My lord.
Correct.
That is
Your counter.
my lords, that running page I don't have.
Those pages are changed. Huh? $24.
My lord.
That is at page 47. Resolution.
My lord.
That resolution says, correct?
My lord.
I will.
I bring your lordship's attention to internal page 12 of that resolution.
Internal page
12. Clause 14.
Clause 14.
Well,
Appointment of staff.
of staff in the institution. Well, it's subclause 2. The recruitment to new vacant approved posts shall be conducted through a transparent procedure, including advertisement for recruitment of at least 2 widely circulated newspapers by the management. It shall be duly advertised in the district and departmental website along with the notice board of the collectorate.
Now, does it apply to compassionate appointment also?
It is not a case of...
Your case is that it is not a compassionate appointment.
We specifically...
My lord, I am just
in counter we have specifically stated.
I am answering, my lord. Your lordship, that starting that resolution, your lordship said it is on 6/6/2022. But my appointment is prior to that. And
25/1/22.
22. It is for the new after the resolution. I am in 2021. My husband is 2009. So it is no way applicable to my case, and that has that is why your lordship mentions the committee has decided on that basis, my lord. And the only resolution is applicable B/4, my lord. Their counter that the persons, the staff's appointment by the management para 2 of recognized school without being prescribed shall continue as such for 2 years from the date of this remuneration. This is only
Prior to that, my lord. The experience long and possesses requisite in the prescribed post shall be considered while filling the post.
Which is that?
That is their resolution annexer B by 4 and B by page 12 and 13, your lordships. That is a pagination. I don't know what is the page, your lordships. And C by 4 also that has been stated. Page 14. The first page note sheet, it has been mentioned. While filling the post, priority is given to the staffs of the special school who have rendered their services for long and possesses required qualification for the prescribed post. My lord, got it, my lord. Page 14, internal page in their
There is no such suitable candidate available, then advertisement may be made.
My lord.
That's the point.
That is the point.
That is.
And my brother, which was referred, my lord, that is 2022, after my appointment. That's the
subsequent rules there.
My lord. And that question also, your lordship, last occasion raised that how that is applicable between the in between. And
what's your answer? He's appointed much before your resolution is.
My lord, it's only in 2020-22.
No, he was appointed on 25 January 2022.
Yes,
your resolution came into force.
My lords.
Long thereafter.
My lords.
Your resolution is dated 6/6/2022.
My lord.
These resolutions are not retrospective, do not have retrospective effect.
My lords, kindly that very same what is submitted by my friend, kindly page 15. The government, the school should be asked to furnish the list of management appointed staffs having experience at least 5 years as on 1/1/2023 who have requisite qualification against these vacancies. Experience will be assessed based on the appointment letter, attendance sheet, and salary payment documents, my lords. And
these are the notices of DSW.
Had it been a case of rehabilitation assistance, my lord, it would have been
There is your appointment order which says compassionate appointment.
Not the only document, my lord, annexer 4, page 13 is there.
Annexer 4, page 13 of your petition.
My lord.
Have they said that your appointment is compassionate ground, on compassionate ground?
Sorry, that is page 10, annexer 1, my lord. Page 10, that is my authority is given.
Where is that?
Page 10, my lord.
Where does it mention that it's working as attendant?
My lord.
Where is the word compassionate or rehabilitation, this, that, etc.? It says you are honest, hardworking, dedicated, so and so, having good nature and character.
And in para 13, we have specifically stated, counter para 13, page 8, there is no such instruction for extension of benefits of rehabilitation assistance to the legal heirs of the deceased employees working in aided educational institutions.
But the management has kept me in that post, my lord. That has the management.
Where is the government or where is some evidentiary material to show that your appointment is on compassionate ground?
That is that exact document, but I have stated in that the petitioner was appointed after the death of my husband.
No, maybe after the death of husband, been appointed, but is it on compassionate ground?
Even though that is, they have not mentioned the management has power, that is why they have kept after the death of her husband, who was continuing since 2009, my lord, in that post. And
2009. You are appointed only in January.
No,
2020.
my husband.
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 I mean, the worker and died is another thing.
Yes, but they were sympathetical.
You are getting the pension of the husband also.
Let the pension is not.
There is no provision for
No provision for pension.
but approval provision is there.
Approval provision is there.
Approval provision is there. In the very guidelines, resolution dated 6 June 2020.
Rule.
Which is para 11. Para 11.
11F.
Annex that?
That very resolution dated
6 June 2022.
Para 11D. The
11.
government shall approve the number of posts as per yardstick and terms and conditions as prescribed by the government from time to time before sanction of penalty.
Granting aid, para 11.
Para 11D. Small d.
11D.
The government shall approve. The sentence begins with
The government shall approve the number of posts as per yardstick and terms and conditions as prescribed by the government from time to time before sanction of granting aid. So even those appointed before sanctioning of granting aid,
yes.
it is power is there with the government to approve such appointments also.
Yes, yes. Although these are special schools, but these are all aided institutions. Therefore, in one of the judgments of our own High Court, it is by the Honorable Single Judge and it was affirmed by the Division Bench that even Education Act is applicable because this is an aided institution and institution has been notified under Section 3B of the Orissa Education Act. So therefore, in case of termination also, Section 10A is applicable, prior approval of the concerned authority.
So they are governed by that only.
Yes.
Yes.
There is a judgment.
69 Act.
69 Act. There is a judgment. Once I have it. Yes. This is by Honorable Justice Chief Justice Ansaria and Honorable Justice A. Prasad.
Yes, brother, you have power to approve the appointments made earlier to granting aid. But anyway, when you were appointed, granting aid was already there.
Oh,
Well,
yes, yes.
Yes, it was already there.
It was.
husband also.
Therefore, we need not
got
travel
the-
to this provision also. If you have power to approve appointments made prior to granting aid, obviously you have power to approve appointment or not to approve in respect of appointments made post granting aid. It goes without saying that.
It is subject to fulfillment of certain conditions.
Conditions.
My lords.
Fulfillment of
That
conditions.
condition was imposed by the committee.
Your condition is 5-year service requirement.
Yes.
That requirement was not complied.
Fulfillment.
Now the 5-year will be over when? 27. January 27. The committee imposed that condition.
My lord.
Where is that condition?
My lords, the power to impose condition is there. My lord.
Huh?
My lords,
Huh?
the government,
Where is that condition? 5-year is a must for approval.
that is page 13.
Page 12.
12.
12 of your SO, your counter.
My lord, page 12, Annex 3 in my writ petition, your lordship, they have make a for sending the name for approval. In third column, they have put it that as on 1/1/2023, 5 years experience. Your lordship, page 12 of my writ petition, Annex 3. In column 3, they have imposed first time, my lord. But the government has stated that the experience and the person should be given approval and holding the
District
post,
Social Security Officer.
my lord.
No, who has imposed this condition of 5 years?
That is the, my lord, the district authority has stated that it has been decided by the
modalities has been decided by the committee. In the first paragraph, they have stated that.
So which is that committee?
That committee, my lord,
My lords, page 13.
Committee,
14, my lords, annexure 4, C by 4, your lordship kindly. It is annexed to counter, my lords.
Committee.
Now, which committee? What is the role of the committee, under which act it functions?
My lords, that is under that circular.
Thus, but that page 12, like, that has been mentioned that as per our discussion held in my office 19-1, some of the modalities have been approved by the collector. That they have mentioned. Right? Thereafter, they have imposed that 5 years. That top.
The committee did not prescribe 5 years.
Government has not prescribed. The committee, they have prescribed that 5 years.
Who has power to prescribe conditions under the rules? Who has power to prescribe these conditions? Under the grant in aid, do you have grant in aid code?
My lord.
Or act?
Grant in aid code.
Grant in aid. Has it got statutory force? Mr. Swain, whether grant in aid has got statutory force or only executive instructions?
So this is resolution.
Resolution.
Resolution under the act.
Under the act? Which
that Disability Act 2016.
Under that act.
Under that act. The super is granted.
And
the modalities have been given in that resolution itself. Previously also it was there. Your Lordship, I kindly see that is
5 years was there, requirement was there earlier also.
No, 5 years requirement was not there.
5 years requirement as on which date?
My lords, date of consideration.
As on the date the consideration.
My lords, the guidelines, the government reserves the right to review the yardstick for the teaching staff.
Yardstick is there.
Through executive instruction from time to time, my lords.
That is teaching staff.
Teaching and non-teaching, both.
But you
and my lords,
teaching staff.
My lords, annexure C by 4, here the committee has fixed my lords kindly see annexure C by 4 at page 14 of my counter. It refers to earlier writ petition filed. Well, let's be
C by 4.
well,
What it says, resolution number so it's a guideline for establishment, recognition, granting aid institution important to children with disabilities.
That you have
referred for prior to should ensure well filling of the vacant particularity given to staff of the special school who have rendered service for long and possess requisite qualification for the prescribed. If there is no such suitable candidate available, then advertisement made for filling up of the vacant post. This is dated.
This is 23 to 2023.
And this was my lord prior to.
And next page,
27 for
5 years is there. This special school should be asked to furnish the list of management appointed
Having
staff.
long and the requisite qualification. It does not prescribe 5 years.
My lord, next page, your lordship. My lords kindly see. Page 15, bullet number 1. The special school should be asked to furnish the list of management appointed staff having experience of at least
5 years
I, Jan 123, who have requisite qualification against these vacancies, experience will be assessed based on the appointment letter, attendance sheet, salary payment.
My lord, to that, your lordship, just prior to that, to carry out the process of selection, the following process may be followed. And this is in respect of the district committee by the, because the starting the chief functionary of 9 school, that is in respect of the Baleswar. And the government decision is just there prior to that page. And this is the note sheet of the authority, district authority of Baleswar, DSSW. This is the note sheet for these 9 schools, not for the government. And the government is, your lordship just read it that having long and possessive experience, if there is no suitable, that is the government guideline. And this is these note sheets are the district authority adopted in the selection. Because
government, for the purpose of granting aid, it prescribes certain conditions. Maybe it will not be inuring to your benefit. But government, as a matter of policy, say you should have put in 5 years as on particular date, because it takes into account the treasury strength and other things.
But that is not the government decision. That these note sheets are the same selection committee authorities notes, not the government. Because your lordship, the first line says the chief functionaries of all 9 special schools of the district, means that Baleswar district, which are. And they have stated that to approve these modalities we are now adopting. They have stated. And the resolution that they have annexed in B/14. B/14 is the government resolution. Your lordship may see page 12. They have annexed to all collector for the reiterating the same, but they have not stated that. The DSS should page 12 of their counter. That is the resolution, wherein they have
recommendation of the selection committee.
Who have rendered the long and possessive experience, but not 5 years.
Experience means now they have given, but experience, otherwise your experience will not have any meaning at all.
Shall I pray, my lord, to let them approve my poster? So I may be granted the GIA after 5 years.
You consider after she completes 5 years.
Because my husband was granting the GIA.
That makes no sense.
My lord.
The husband and wife in English law till 1891, they were considered to be one. But after 1891 Amendment Act, the husband and wife started having the independent personality. What husband did that makes...
No, I just brought your lordship.
And you are not showing, why I am saying this is, you are not showing that her appointment is on compassionate ground. Otherwise, I would have trimmed this judgment with compassion.
My lord would be having 1 orphan children.
You did not take permission of the government before begetting the children. What government should do?
Is done.
The short grievance of the petitioner is expressed in the prayer column as under. First down. Kindly be seated. Sit down, sit down. Learned counsel for the petitioner argues that her husband having died, her client's husband having died on 23/8/2021 in harness, petitioner widow came to be appointed as a cook bar attendant in the OP school, which is meant for specially abled children. First off, when appointment was sought to be approved, necessary information was furnished by the school authorities to the jurisdictional OPs for processing, and that in a way they had recommended case of the petitioner for approval and granting aid. First off, that having been not done, petitioner is grieving before the court, complaining before the writ court. First off. Next paragraph. Learned AGA appearing for the OPs draws attention of the court to the policy documents which are annexures to the counter filed resisting the petition. First off, these documents, according to the AGA, require compliance of policy conditions prescribed by the authorities, and one of the conditions is that the employee should have put in a service of 5 years. First off, that condition admittedly having not been complied with, no relief can be granted to petitioner, the appointment itself being of 25 January 2022. First off, there is the force in this submission. Next paragraph. At this stage, learned counsel for the petitioner submits that let the approval be granted to the appointment of his client, subject to the rider that immediately after completion of 5 years, her case should be considered for granting aid. First off, there is a force in this submission in as much as the policy documents with learned AGA pressed into service in resisting the petition do not lay down a policy as a one-time measure, but for repetitive actions. First off, in a sense, these policy guidelines have the elements of subordinate legislation, arguably being relatable to the provisions of Right to Education Act. First off, next paragraph. In the above circumstances, this petition is disposed of, directing the jurisdictional OPs to consider the case of petitioner for appointment of her approval of her appointment to the subject post, and that after she completes the service of 5 years, her case should be considered for granting aid as well. First, no cost.
Time period for approval.
For approval, that itself is doubtful, because approval is coupled with the decision to grant in aid.
Your Lordship has already mentioned everything that they have to. Only they have to, otherwise they, since the consider, they may again put reject or say that
That is why the Lordship have to discuss everything. Only for approval, that
Role of appointment within 3 months. There you can enter. Okay.
I may part my note. From the list item 40. 40, yes. My learned friend Mr. Mahanti AGA, he has some difficulties, some bereavement in his family. He used to argue, as I have been told by my senior Mr. Lenka. So can it be next week, my lord? And other cases and other court.
Next week may not be.
Any date, my lord, the kindly fix.
Week after next.
Yes, 12th or 13th, my
Let us
mention my lord.
put that.
My lord. 11th, my lord, may I pray 11th?
11th, it appears I have already posted. Let it be. Let the registry look into it. Week after next it is.
admission, mathematics, school, small children's question of admission, my lord. May I pray tomorrow? Tomorrow. 3 to 4 days and children, and that be holiday. Take that.
Part 2 to mention, my lord, this is a transfer matter, my lord. On the ground recommendation of the MP and MLAs, my lord. So, lordship can take out tomorrow, my lord. Oblige, lordships.
May I pardon for last item, my lord? That is under the heading of referral to mediation, but it was held by your lordship. It cannot be referred to the mediation because the files of the notification is challenged, my lord. My senior, designated senior, Mr. Dayanand Mahapatra is appearing on behalf of the BDA. May I pardon a short adjournment any convenient day? Because the last item, it will take time, my lord. I have some difficulties. Any convenient day of your lordship.
In the 3rd week of
Oblige.
it should not be in the mediation day.
No, my lord. That was held by your lordship last occasion.
The matter is not fit for the mediation.
My lord.
That has already been.
Oblige. I will intimate this to senior.
Yeah, just
I will inform them. Oblige.
Yes.
Item 30.
May I please?
Yes, sir.
Your lordship had given me a homework to find
I
out.
also do homework.
To find out the aid of the Supreme Court's order to be, that is, my lord, Article 144 of the Constitution. I found out.
That every
Order. Let me place it.
Correct. 140.
So actually, I was
in aid of the Supreme.
actually I was searching Order 21, but actually
CPC.
no, it is 144.
In Karnataka, in the CPC, that provision is added.
Has been added. That's state amendment.
Yes, state amendment.
And under which provision? Order 21?
Under Order 21 only. Order 21, Rule 24, Clause 1A, something like that. Karnataka amendment.
I will check up that. And this is all authorities, civil and judicial in the territory of India shall act in
Aid of Supreme.
aid of the Supreme Court.
Correct. Okay.
Now, this is a perfect case where an arrangement was entered in the Honorable Supreme Court between A and B.
Where is that?
That arrangement, my lords, your lordship will find filed on 8/11/2021. This is the order. Can I pass it on the order?
Yeah.
Execution भी अच्छा है. That is also there in their counter and my execution petition.
Yes. Kindly press that on.
Yes. The appeal above mentioned along with connected matter been called on for hearing before this court on 27th day of March 1992. Upon perusing the record and hearing the counsel for the parties, this court passed
doth pass the following order. Appeal stands disposed of in view of the settlement between the two contractors parties herein duly signed by the council, placed on record. Contained there is an obligation on the state of Orissa to identify the cut-off trees. We direct the state to fulfill this obligation towards working of this settlement. And this court doth further order that there shall be no cost of this appeal in the court, that the orders of the court dated 8th January 1979 and 27th April 1979 passed in civil miscellaneous petition number so and so in the appeal, granting stay and direction to be hereby vacated. And this court both lastly ordered that the order be punctually observed and carried into execution by all concerned. Now, my lord, the settlement is at Annexure A by 3 to their counter. OP number 2. OP number 3, sorry, OP number 3.
Memorandum of settlement.
Yes, I'm grateful. Should I?
Just since the marking of the trees not visible now. First paragraph.
Yes.
Yes.
The state of Orissa should be directed to mark the balance standing trees afresh with Forest Department.
No. Memorandum of settlement is filed. First paragraph.
Since the marking of the trees are not visible now, comma, the state of Orissa should be directed to mark the balance standing trees afresh with Forest Department. Number 2, the 4 installments required to be paid should be paid as under 50% by the appellant and 50% by the respondent. Payments already made by the parties should be adjusted against their respective shares.
Correct.
The felling operation of the trees, etc., may be done through Orissa Forest Development Corporation, which is a state government undertaking concerned, and the operation expenses will be borne by the appellant and respondent equally. Number 4, after operation of the coupe, the timbers and the firewood will be divided equally after taking into account in quantity of timber, firewood already removed by the appellant, Udayanath Saul, and the appellant and respondent will take delivery of material and they will remove the forest material on the strength of a coupe. Permits to be issued by Forest Department in favor of the appellant and respondent. This is the memorandum of settlement entered between A and B, and there was a direction to the state government, because the forest belongs to the state government, direction to the state government to identify and do the needful. Now, your lordship may kindly see flag A, that is flag A, that is notes I have submitted on behalf of the decree holder. Now, they had filed the state was called upon to file an affidavit. In 2021, they had filed an affidavit. And subsequently, on your lordship's direction, they had filed an affidavit day for yesterday, and they have served a copy. It's a verbatim reproduction of what in 2021 they have stated.
What are your notes?
My notes, yes. May I please?
Yes.
That as per the agreement between the parties, in all, 747 trees were marked to be felled, and the petitioner was entitled to get 1/4 of the total number of trees felled towards first installment. The allegation that the petitioner has lifted 183.81 is ill-founded. It is submitted that a contractor cannot remove the timber
without the same being passed by the forest department. I cannot take a timber outside the forest without being passed from the, they have to give certification.
Pass.
Absolutely.
Transit pass. Yeah.
Transit pass. TT, transit, timber transit pass. The timber can be taken out of the forest only after thorough physical verification by the forest officials. Conceding for the sake of argument, though not admitting that the petitioner has lifted more timber than the sanctioned quantity, the same can be adjusted from the other 3 installments which the petitioner is entitled to lift. The submission of the opposite party, they have stopped felling of trees after 1997, is false. The petitioner way back in 1993 has filed an affidavit before the Honorable Supreme Court wherein he has produced bills which will show that opposite party was still into auction timber by OFDC. The petitioner takes leave of this court to produce bills of 1997-98 before this court. I can pause here for a moment to show something very interesting. That
the felling took place even after that cutoff date.
Lordship, may kindly see the date. This is dated 2/8/2025. They have auctioned.
Even now they have done. But even after that,
what are auctions? These are which are seized and which trees which have become old, which are felling. They are auctioning it.
Is it permissible, Godavarman?
Yes, felling of trees is not permissible.
But
which are
can be
dead trees which are fallen or which are seized. Number of timbers are seized by the government. Those are channelized through Odisha Forest Development Corporation and put to auction. This is the latest which I got it from the website.
This auction is by the Development Corporation, but not necessarily the felled trees. The trees may be seized.
Maybe seized. Just for the sake of that, they are doing it.
Available like that.
It's available, yes. Right. Now, paragraph 3. That the contention and objection by the state government in execution case was agitated before the apex court in interim application number 2 and 3 of 1993. The said contentions were rejected by the Honorable Supreme Court in order dated 28/1/1994. The objections now are therefore barred by the principles of res judicata.
What is the 28/1/94 order?
They had filed application, interim application, that felling of trees has been banned and we cannot fell trees. And secondly, there is a notification that Shimlipal is a reserve forest. These 2 applications, interim applications, were filed before the Supreme Court. Supreme Court rejected that. Because you have entered, now you find out how to give effect to this settlement. Now, my lords, may kindly turn to the next page. That is the bill of 1997, which shows Odisha Forest Development Corporation are auctioning and they have woods with them. Then I have made things more easier. If your lordship may kindly turn to the next page, like the additional affidavit. Lordship got the additional affidavit? That same.
Yeah.
It's an additional affidavit which, my lords, for the Honorable Supreme Court, that if you are unable to give, then the calculation sheet is the next step. Next page is the calculation sheet. Total number of trees marked, soft boughs, balanced trees to be felled. Udayanath has felled after payment of first installment. I had paid 53,000 and I have removed 170 trees. That I admit. Balanced trees to be felled 577, so and so, so and so. And now thereafter, I have made a calculation that if you are unable to give me that.
You mean cash?
I rest my case on that. And your lordship know, execution case, executing. Get any clarification, they should have gone to the Supreme Court.
And their interior application were both rejected, modification were rejected. So they are bound by the orders of the Supreme Court.
Is it not a contract becoming void because of apex court decision? One aspect I am asking you. Any standard books on law contracts like Chicky on contract, like Cheshire, Fifoot and Farmston on contract, Anson on contract.
Section 28 of the Contract Act, if I remember, says if a contract which is against the state government, which cannot be carried out, policy against the state policy, and which cannot be carried out.
Becoming what? Chicky on contract deals, of course.
That's the most costliest book of contract.
He is one of the finest books.
One of the finest
Authorities.
Absolutely.
Colonial countries.
Absolutely.
They follow that.
Absolutely.
Cheshire, Fifoot and Farmston. Wonderful book. And
Mullah's contract is also.
Mullah's contract is, many people do not travel beyond Mullah at all.
I know.
That is Frederick Pollock and Mullah.
Frederick Pollock and Mullah.
Frederick Pollock and Mullah.
Correct.
Two aspects. After you argued the other day, I again went back in my memory of my bar days, the happy days. If a contract gets discharged by performance or becomes void by nova causa supervena, like new cause, like
has come,
that comes in the way of discharge.
Executing the contract.
But whether that clothes the other party or the party obligee, can be told, no, the judgment has come in the way, law has come in the way, therefore I cannot fell the trees. And therefore contract has become impossible of performance.
Unworkable.
Impossible of
Impossible.
Performance. This is the concept of it. Unworkability is another. She treats that also separately. Whether you can say contract in its substance might have become unworkable in a particular way, but recompensate is possible. Whether right to recompensate arises under a contract whose performance has become impossible because of certain directions of the apex court. I think this will be the core issue involved in that case. You mean to say that right to recompensate, what it is called, I do not know. Some books say recompensate, other books say damages. I do not know exactly. If alternatively, if you are saying that even now this wood is being sold, logs are being sold, then they can't say that they cannot fell the trees. That will not be the available ground. This is one aspect. The other is assuming that they say
there is a ban.
There is a ban.
So what is the alternative to execute the
How this alternative is worked out in contract jurisprudence?
Now your lordship may see this affidavit with the calculation which I have made was before the Supreme Court. Now Supreme Court, while dismissing their interim applications for modification, you work out your remedies. So my case now comes under the definition you work out your remedies in the.
Otherwise Supreme Court would have said, no, we have given Godavarman, therefore nothing can be done.
Nothing can be done.
That they did not say.
No, you work out your remedies. So I come under that. If this is not possible, then that is possible. So that needs to be executed. And this calculation which I have given is in 1996-97, 2025. So interest obviously has to be
calculated on that.
How any rulings as to how this should be the alternate is possible, and therefore they are completely not discharged from their obligation.
I got one judgment of the Hon'Ble Rajasthan High Court. It was in a different context. It says the court directed that salary is to be paid. Now, whether bonus is part of the salary, it was under Order 45 Rule 5. That's the only solitary judgment which I got. Bonus, gratuity, whether it forms part of the salary. So the High Court said that we cannot enter into that. Then it went to the Supreme Court. Supreme Court reversed it. Call of salary is salary. It includes everything.
No, how that is relevant?
That is relevant that whether if in the orders of the Supreme Court has to be read in isolation. One, isolation along with the memorandum has to be read along with the memorandum of settlement entered between the parties. It is not that state was not represented. State was represented by the Advocate General, and the Advocate General after the settlement had not pressed the appeals before the Supreme Court.
So it partakes the character of a compromise decree.
Yes.
And there is no difference between a decree obtained in full-fledged trial and compromise decree when it comes to enforcement. Is your subject?
Yes.
Let us see what Lenka will say. English authors call it as frustration of contract.
Frustration of contract. I actually, it was
Indian authors like Khergemwala, who edited the Mullah's Contract Act, and there is one more, K.C. Shawaksha, Mullah's relative also, but he edited the Mullah's Contract Act for the purpose of students. K.C. Shawaksha, perhaps you can take out from Google. It's one of the best authors. During my student days, my professor Ramachandra used to tell about these things, how contract becomes frustrated, how doctrine of frustration operates in the Scandinavian countries, in Australia, in India, colonial countries. These things, very comparative. He was a very great scholar. He used to say that. Just one small paragraph, see how frustration of contract from K.C. Shawaksha's Contract Act may be available in Google. You can take out that paragraph. Maybe Google will come to you.
Google. We get enriched day by day appearing before your lordship. I know lordship is also
in this. I am only saying what I had read long.
It's
what I have been taught.
The vast knowledge which we get.
No, you also will have vaster knowledge.
No, but it gives an encouragement. It gives an encouragement to study further.
Many students sit in my court hall. Many youngsters sit in my court hall. So the court hall should be not only a unit of adjudicative process, but it should be educative to the judge also. To the judge also. And bar members are learned. For them, they do not need any learning. But judge needs to learn every day.
Yes.
What's your defense?
I prepared a short
note,
lecture and also a note with some citations.
Please give.
That will help your lordship to appreciate better.
There is a method of giving the citation.
Yes.
Apex Court in 2018 said, that was a case that arose from Himachal Pradesh. What you will do is, you will dump citations at my table. But I am a human being. My time is limited. And within that, I have to ration out everything to people, consumers of justice. Yesterday, I went through the papers. Simply, they have stitched rulings, about a dozen rulings. Below, I do not know whether petitioner has filed it. Only signature is made. Whether petitioner's rulings or respondent's rulings or rulings of some other case which our officers have inserted by mistake, nothing could be understood by us.
No, Your Lordship, I have. According to yes, according to Your Lordship's view, I have prepared in that way.
That's great.
Yes. That Your Lordship will find from me. So let me first place the date chart.
75.
Yes.
All this happened during emergency.
Yes.
Yes.
50, Your Lordship is going to decide the issue 5 decades before it was filed in this case. Your Lordship, I have quoted the prayer made by my learned friend in the execution case, that the judgment debtor in the date chart itself, in top, that the judgment debtor may be called upon to implement the directions given by the Honorable Supreme Court of India by identifying the on-court trees. And in the event of this Honorable Court is pleased to hold that the trees so identified by the judgment debtor should not be cut to avoid ecological imbalance. The judgment debtors may be directed to supply equal quantity of logs to the decree holders from any of the depots of the forest department in the state. Cost of the execution may also be ordered to be recovered from the judgment debtor. That is the prayer in the present execution case. Now, I will go to the Supreme Court. My learned friend has placed the order, memorandum of settlement and the order passed by the Honorable Supreme Court on 27th March 1992. Before I go to the date chart, I will once again take your access to that order of the Honorable Supreme Court. That is paragraph annexure A by 3 to my counter filed by on behalf of the opposite party number 3. Just now my learned friend was showing. The language
Settlement.
Yes. That is important. Why I am repeating this.
Yes.
Number 1. Since the marking of the trees are not visible now, the state of Orissa should be directed to mark the balance standard trees afresh with the forest department. That is their memorandum of settlement before the court. Then 4 installments required to be paid should be paid as under, that is 50% by the applicant and 50% by the respondent. Payments already made by the parties should be adjusted against their respective shares. I am skipping paragraph 3. Then paragraph 4. After operation of the coupe, the timber and firewood will be divided equally after taking into account the quantity of the timber, firewood already removed by the appellant Udayanath Sahu, and the appellant and the respondents will take on the strength of coupe permits to be issued by the forest department in favor of the appellant and respondent separately. That I need not demonstrate that to your lordship that works.
One more ask.
Yes. Then your lordship may kindly come to the order.
1 second.
Yes.
Frustration of a contract is one thing. Frustration of the decree of the highest court of the country is another. The Contract Act, law of contract, speaks of frustration of contracts. Though a compromise decree is called a contract with the seal of the court, A subtle difference between these two does exist. That is a contract simpliciter, a contract on which the decree is founded. So, difference between compromise decree, I am repeating, and full-fledged trial decree, there is no difference when it comes to execution. Firstly, can you plead impossibility of performance?
Yes.
Is one.
Yes.
First thing is we should understand what is ordered.
No,
This is ordered.
yes.
Let us agree on what has been agreed upon. The agreement between the parties, apex court of the country took note of that, granted an order, decree, whatever.
Yes.
That is now put in challenge. What is your defense to that?
That I have already explained in my note, and I have brought also some citation on that point.
No, just tell me the
Yes.
first point.
Yes.
First objection to the
The
execution.
first objection is, your lordship may, just I was going to take your lordship to that order dated to
Apex court.
Apex Court. Last one.
Yes.
Apart from that has been stated, and this court doth lastly order that this order be punctually observed and carried out, execution by all concerned, not only on the part of the state, also all concerned includes the appellants. All concerned. Because, why I am telling so, then your lordship may kindly come to the my date chart. That your lordship will be clear.
Did you file an objection to the execution?
Yes, sir. Yes, sir.
That objection.
That is the affidavit that your lordship is saying.
The affidavit now filed. In the original execution, any objections were filed? Not filed.
Previously, opposite party number 2 had filed an affidavit. Now, OP3, the principal conservator forest, has filed 3 days ago, and that is an
Assistant conservator.
yes. On behalf of the, then your lordship may kindly see
Where is that?
affidavit.
Affidavit dated
Affidavit to 19/8/25.
19/8/25. Now
Yes.
filed.
Yes. Previously, it was filed by on behalf of the opposite party number 2.
1 second. You were a small foundational facts.
Sorry.
You can sit and answer also. What was that execution case number 2 of 1997?
Yes.
Execution case. But this was preceded by the order of the apex court, na?
Yes, yes.
The order of the apex court is 14/7. No.
14/7/94.
Huh?
No. 27th March 1992.
The settlement you were reading,
Settlement.
dated the 75 settlement.
27 March. Well.
27th March 1992.
Settlement.
Yes.
Yes.
Before the apex
Yes.
court. Settlement. Recorded by the apex court is dated
27th March
1992. First up. Order is made by the apex court on that when? The Supreme
on 27th March 1992.
made the order on 27/3/1992. 1992. First up. You had filed execution case number 2 of 97. Execution case number 2 of 1987. Why 5 years nothing was done?
No, there was a problem. What I did, I went to the lower court to file execution. The lower court said, I have no jurisdiction to execute the Supreme Court's order. So they dismissed it. Then I came to the High Court. Under Order 45, this delay that is the reason why there was a delay.
For execution of decree of the kind, how many years?
12 years. 12 years.
You filed your objection to the execution.
Yes.
What is that? Where is that original objection?
Original objection. At the 11/2021.
For 97 execution.
Yes.
Yes.
Objection.
It's not an objection. It's an affidavit.
Taking form of
Objection in the form of affidavit.
post.
Dated
11/2021.
11/2021.
2021.
As per the direction of this honorable court on 28/9/2021.
Only after court directed you filed objection.
Such is the honorable fact.
Pursuant to order of this court made on
28/9/2021.
28/9/2020. If a decree is put into execution in Karnataka, the question of objection will not no notice to other side. If it is put in execution within 2 years, whether such a rule is available in
Objection by the judgment debtor. He has, your lordship knows, order 21 till rule 105.
Yeah.
He can file objections. Order 21, rule 97 to 99 is a stranger.
No,
So they have.
That is different. That is obstruct or supplication. I am asking objection to execution.
There is no, cannot be.
Cannot be.
Available in under section 47 of the CPC.
47(8).
Yes.
That is
Execution, discharge, or satisfaction.
Satisfaction. Yes.
CPCW.
Very good. What was the contention taken up in that first affidavit?
Affidavit.
Affidavit of 2021 affidavit you mentioned.
Yes.
Huh?
Yes.
Under that, what were the objection?
That objection first was the obligation on the part of the appellants, the decree holder, were not fulfilled.
What are the obligations?
Obligations was memorandum of settlement, point number 2.
Kindly read the point
Yes.
number 2.
The 4 installments required to be paid. 4 installments required to be paid should be paid as under, that is 50% by appellant and 50% by the respondent. Payments already made by the parties should be adjusted against their respective shares.
What was the amount
Then,
payable?
till then, only one installment was paid first.
One installment was paid.
Paid by Udainath Sahu.
On which date?
That was paid before 15/11/1977. I have brought the contract. Out of which this present execution case is there. Your lordship, I'll have a look.
Now, once I'll look into, but
Yes.
once the seal of the court is put,
Yes, everything is there. Seal of court is there. Seal of court is there. And also on our part, we have not violated any of the order. That is why I was pressing to lordship to see my lecture. It will be easy to understand the case. Yes. Lecture. 29/11/1975.
Coupe ratified.
Yes. Forest Coupe ratified in favor of R.S. Bhatia, now decree holder number 2. Then the auction was there. Decree holder number 2 got the auction and it was ratified in its favor. Then contract of R.S. Bhatia terminated as the installments in terms of contract not paid. Decree holder 2, whose favor it was ratified, he didn't pay the installment.
Then appeal by R.S. Bhatia before the appellate authority considered and rejected. Then said coupe was put to re-auction and ratified in favor of Udayana Sahu, the decree holder number 1. Present decree holder number 1. Date now so-and-so. Copy of contract is annexed. Accordingly, out of 751 numbers of trees marked, 170 numbers of trees were felled, total 822 logs conversion, out of which 754 logs removed, leaving behind 68 logs. That is by
whom?
Udayanath Sahu, decree holder number 1.
Who is with your claim?
Yes. Now his plan. Now both are in their hands. And both of them approach the Honorable Court by a memorandum of settlement. Then OJC number 82797 R.S. Bhatia moved the Honorable High Court by the OJC number so-and-so against the order of termination of contract. Writ application was allowed by this Honorable Court, quashing the termination of contract of R.S. Bhatia, whose contract was cancelled, quashed, that this Honorable Court upheld and R.S. Bhatia got that coupe. Then civil appeal number so-and-so, UN Sahu, the decree holder number 1, moved the Honorable Supreme Court of India against the order of Honorable High Court. Civil appeal number 63 of 79, state also moved the Honorable Supreme Court of India against the order of Honorable High Court. 27/4/1979, R.S. Bhatia approached the Honorable Supreme Court and Honorable Supreme Court stopped the war, completely stopped the war. Then on 27/3/1992, R.S. Bhatia and UN Sahu, both decree holder 1 and 2, filed a memorandum of settlement before the Honorable Supreme Court of India, which was accepted and the order was passed. Then
You were also party.
yes, 63 was filed on behalf of the state. That was subsequently not pressed and accordingly it was dismissed. The word is there, not pressed by the state. Then, Your Excellency, IR number 213/93, the state government moved the Honorable Supreme Court of India for a modification of the order dated 27/3/92, part in civil appeal number 62/1979, that is on behalf filed by the decree holder number 1, alleging that felling of trees was banned under section 29 of the Wildlife Protection Act 1972.
What Apex Court say?
Apex Court said that is
Rejected.
no, not rejected. Your Excellency, that is his language. My learned friend has used to reject it. He is exactly not rejected. Then they also moved to contempt petition. Contempt petition number 273 and 274. Go on to the matters. I filed on behalf of the state and the contempt petition filed by the decree holder number 1 and decree holder number 2 were disposed of. We do not propose to proceed any further in those contempt petitions. Proceedings are dropped and IAs are rejected. Parties then parties may work out their rights in appropriate fora. That was the order, both in contempt as well as in the IAs. Then what happened, my lord?
So your applications were rejected.
Yes. Along with the contempt petition and the all were taken together and one order by 28/1/1994, common order, 28/1/1994, the Honorable Supreme Court rejected the
Contempt
and IH and directed the parties to
work out their
rights in the appropriate forum. That was
because it was a decree.
Yes.
And for against the violation of decree, generally contempt petitions are not entertained.
Yes.
Maybe that may be that one of the reasons.
So in IS, our stand was, since the area has been declared under section 29 of the Wildlife Act 1972 sanctuary, so felling of trees has been prohibited. That was our.
But that contention was available to you when Honorable Supreme Court was recording the compromise. 72 Act. Compromise happened
Yes.
91 March.
Yes.
Petition 1 March,
Yes.
27-3.
Yes.
92.
92.
92.
Sorry.
That time,
Yes.
your 72 Act was very much there.
Very well, yeah.
You did not oppose the apex court, saying that, sir, what you are doing will run counter to the provisions of 1972 Act. Therefore, you don't.
It was not out of ignorance. It was not filed then. Subsequently, in the IS, it was filed and it was
It also rejected.
rejected, directing, not rejected exactly, directing to go to the appropriate forum. So option was open. My argument before also, option was open.
Option was open for.
Open to approach the appropriate forum.
If the order is passed by the apex court,
That I will satisfy. We are querying, I will satisfy.
in that order you have to go to Parliament. Parliament can do that. In the Atiyabari case, Atiyabari Tea Company versus Joint, which is now overruled, that's another thing. Just take up that Atiyabari.
This
Atiyabari Tea Company versus Joint Supreme Court judgment. Go to other forum means that is for execution of the order, not for nullification of the order of the apex.
Well, execution of the order, so far the decree holders are concerned. When decree holders, when in our application and contenders all taken together and by the common order, it was passed that the parties may work out their rights in appropriate forum. So it is not exclusively for the.
According to which forum?
So far the state is concerned. So far the state is concerned. The state is concerned once that has been prohibited and the state authorities' hands are tied down. And your lordship, that also your satisfaction or lordship, I brought one decision on that here. That I will place. Your lordship kindly come to.
No decree should be passed contrary to law is the grand principle.
Yes.
But once a decree is passed against contrary to law, that decree is not executable. That is arguable. The ground which you could have pressed into service for resisting drawing of a decree, passing of an order. If that ground is not urgent, can the executing court look into whether this decree is contrary to law or not?
Yes.
The doctrine.
Yes, my answer is yes.
How?
Yes, your lordship, I will come to my note of submission. Then first page, second page I am skipping.
That is supposed to go in behind the decree.
Yes, I will satisfy your lordship.
Except apex court in 1954.
Yes.
Kiran Singh versus Chaman Law, AR 1954, page 454 or 457. Just looking.
I have brought.
Decree can be resisted only on the ground that the court which passed the decree had no jurisdiction.
Yes.
Or decree is inexecutable by its very nature.
Year 1962 Supreme Court 1230. Haji Sheikh Subhan versus Madhe Rao.
2 judges or 3 judges? Which is that?
2 judges. Their lordship held that if the decree was passed in ignorance of the act, means Wildlife Act, which was before the order passed by the Honorable Supreme Court, the executing court can refuse to execute the decree, holding that it has become inexecutable on account of the change in the law.
There is a change in the law. 72 Act was very much there.
72 Act was there. Subsequently also changed. The Supreme Court itself banned the cutting of trees in Orissa after 99.
But you have told so much of by action.
That is there. That law also protects. Right trees and those trees have been fallen in the field.
Give same thing.
Question will not arise because they have not they have not fulfilled the obligations on their part.
What is that obligation?
That is obligation that they have to pay the balance per installment.
When it should have been paid?
It should have been paid. No.
On which date?
Which that
even when
first installment they paid they have to paid on 15/11/77 only.
No. You are
15/3/78, 15/10/73 and 15/2/1979.
all right. When you took up the stand that we will not execute, we will not discharge the decree, even then they should make the payment.
No, we have not declared that.
You had said that.
No.
You resisted what were your applications for?
Application that they have not discharged, they have not performed in their.
That is rejected.
Yes. Yeah. Your Lordship may see, if they will not deposit, the forest rule says, Your Lordship may kindly see.
No, anyway, all this is examined by the apex court. Where is something for Justice Dixit to examine? Am I not Supreme Court?
No, all these things have not been
You seek recall of the order.
For that we have approached the Hon'Ble Supreme Court by way of IA.
I rejected. You should be happy with that.
No, IA rejected.
Rejected by the apex court.
Yes.
But now you allow the application is your contention. If that contention was already treated by the highest court of the country and rejected, can a court subordinate, if not subordinate, below in the hierarchy, say, no, we will allow this that will be restituted.
It was part of the memorandum of settlement that they will pay the balance installments, but they didn't pay.
That's all right. Based upon that only you moved the application.
No, we moved the application that since that area has been declared as a sanctuary in terms of Section 29 of the Wildlife Protection Act, so that the order should be modified. That was our main contention in the IH. And your Lordship may kindly see.
The applications were rejected on 28/1/1994.
Along with the contempt petition.
Leave contempt.
Yes.
Contempt of execution is different.
Yes, sir.
But your application, you had taken up certain contentions to resist execution of the decree passed by the apex court on agreement.
Yes.
To that proceeding also you are a party.
Yes, you are a party.
Though you are not a signatory to the agreement. You were not a signatory to the agreement, but he was a party to the decree.
Party to the decree.
And the apex court said all should act to execute this order. Word execute is appearing in the order of the apex court. The word execute appears.
The order of apex court, my lord,
employs the word execute.
Yes.
Certainly it is not you. It is the decree holder who will execute.
The
last
yes, and this court doth lastly order that this order be punctually observed and carried into execution. Carried into execution by all concerned. All concerned means state as well as the decree holders, the present decree holders.
Correct.
So they have not performed their duties. They failed to deposit their obligation.
Where is that contention taken up in the affidavit of 2021?
21. Yes, sir.
how much money was payable and they had not paid. Have they taken up?
Can I assist?
No, have they taken up that condition?
On the contrary, they write a letter to me, you get back your security deposit.
Subsequently.
What was the security deposit?
That is annexure B/2, page 12 of their counter affidavit. Security deposit amount of 20,500 and security deposit of 21,406, respectively, of two decree holders.
Yours is 20,500.
We are both. I'm appearing for both. It is 41,906.
906.
906.
This was paid in which year?
This was paid 77.
1977. Maybe that 1 acre of land could be purchased in Bhubaneswar at that time.
Or maybe more than that.
Where have you said
That in
that
affidavit.
you have not paid money? Therefore, we are not entitled to execute the decree. Where is the contention?
That we have not taken touch on in that.
Now you are arguing in the air.
Because
It should be founded on pleadings.
No, because in the memorandum of settlement, there was a condition that the going deposit is.
That is your argument. Your argument should be built on the battle lines drawn. Battle lines are drawn by filing of the objection statement, your affidavit. Where have you taken up that affidavit? You can't argue something from the book of execution. All many grounds will be available. The author will give so many grounds. You can't argue them unless you have pleaded them. And why you asked them to take back that advance on what ground?
Because your Lordship can see
If money was due, instead of asking them to take back your money, you should have said, make so much payment which is due from your side and get the logs.
your
The
Lordship,
state should stand tall.
your Lordship can see the forest contract rule introduced by the state government.
No, I'll read that, provided you
Yes.
have taken up a contention in relation to that. Otherwise, I will be reading. Whole day I spend a lot of time in reading. That's my hobby. But point is, I can't do it in public time.
Contract was for a certain period.
Correct.
That is Rule 7 of the contract rule.
Correct.
Time is, essence of time is crucial. Once the time lapses, then automatically it's a deeming provision that contract is terminated. That
Have you taken up that contention in your affidavit?
in affidavit.
Yes.
In affidavit, exactly I have not taken the
Then how can you argue?
in the point of law, man.
By point of law.
Yes.
Unless you take up that contention in your objections to the execution.
Yes.
How can you argue that?
It's a pure law, matter.
No. Law is not, it's a mix, whether that law will not operate in vacuum. It operates on a fact matrix, which you should have pleaded.
Yes. Facts,
Pleading is lacking.
yes, facts are there. Facts are there that there was a contract between the decree holder number 1 and both the parties, they filed a memorandum of settlement and the Honorable Supreme Court has ordered but those are the facts are available, man. We have not specifically pleaded in our affidavit.
Whatever is not pleaded, I will not permit you to argue.
No.
Because that will be waste of the time, public time, your friend's time.
Only your Lordship kindly the Rule 7 of the contract rule. I am just
I become a little more.
No, your Lordship put on question why you wrote a letter to refund your money.
Yeah.
So on that point, I would like to show your lordship.
You, 1 second. You asked which is the letter dated, which is that letter by which you asked them to take back the amount deposited?
1/10/1994.
1/10/1990.
And those letters, they could not be delivered. They didn't. Then paper publication was made in local paper.
To take money?
Yes.
No, you should have taken the police to those people to keep the money into that bucket.
What I am telling, that is in the fact, in the affidavit.
Oh, that's going to help you. Mr. Lenka, you're a tall lawyer. You want to look at. Your contention should be based upon the pleadings of the parties. You may give wide advertisement. You may take army to put the purse into his pocket. That is not the question. Question is, did you resist? And you resisted the execution on XYZ grounds. You can't argue other grounds. Yes, that's the law. Execution petition. There is an order. Order is not putting it into the frame and put it to the wall. It is for execution. And the fruits of decree should reach the decree holder. That's the first principle of rule of law. Otherwise, adjudication has no meaning. Think they have.
They have not made a payment. That is what
You never said that. You sent that money back to them.
No, it was. Well, you Lakshmi, they have in the memorandum of settlement, in the point number 2, they himself, both of them agreed to pay the balance contract amount.
Where have you taken the
That is, we have not taken. That is the memorandum of settlement. That is part of the memorandum of settlement.
That is put into execution. You have filed your objection. You have filed your objection by affidavit.
Now, here.
Yeah.
Yes.
All right. After so many years, you have filed it now here.
Yes.
Where have you taken up that contention? Sir, they have not made the payment required of them under the order of the apex court. And therefore, they are not entitled to execute the decree order of the apex court. Where have you taken up that contention?
We have not taken one.
Then how?
You should. We have not taken.
Learned AGA, Mr. Lenka, on being asked, repeatedly conceded that in the affidavit filed in 2021, resisting the execution, the contention that the amount payable and therefore they were not entitled to levy execution. Can we go to next point now?
Yes, sir.
Yeah.
But in the present affidavit, we have just said that first installment has been paid. And for that, the decree holder number 1 was allowed to cut the trees. 751 trees were marked and 170 trees they felled and converted into 822 logs, and that only 68 logs there.
You asked, you wanted to pay back that money now?
Yes.
Why you did not appropriate that money for rest of the logs?
Only 3,000.
We do not know. Whatever. We have your 3,000 rupees is with me. You can get 50 grams of some tree log from us. You take this. That is not your contention. It may be only 3,000 you are speaking of. What was 3,000 when Alexander had come here is not 3,000 today. That was decades back.
Yes.
You should have said, your amount is so much with me. You are entitled to so many logs. 1 log, half a log, a dozen logs, 100 logs, as the case may be. Number 1. You should have said, give us this money. and take so much of the forest goods with you.
Admittedly, my lord, we have not taken that stand, but I will show your lordship in a similar situation what was the consequence, and the matter went to this Honorable Supreme Court.
AGA, in all fairness, submits that the amount remaining was not appropriated by his clients, but
That was
it was
insufficient.
offered back to the
Taken back.
decree holders, which the decree holders did not accept.
And then, yes.
But in that connection, an advertisement in the newspaper was also published.
Yes. No. Then
By
your,
way of notice.
yes. Your lordship may kindly see, in a similar situation in the state of Madhya Pradesh, an auction was held and the party paid only one installment, the rest of the installment didn't pay, and somehow the matter, the forest officials, they allowed him to take the lots.
Yeah.
Without making payment, the contractor took the lots. When the forest authority
They can move application under 47.
No, the forest authorities, what happened, they adjusted their the security money and they attached the property of the surety. One surety was there. That matter went to the Supreme Court. And Supreme Court held that the officials, the forest officials, they are responsible for it. Without receiving the payment, allowed the
Goods to pass?
Yes. That also I have annexed.
But that question arises where payment is shown to be due.
A payment,
It was a case where amount was due.
yes.
Because without receiving money, they parted with the goods.
Here, as per the contract, my lord, your lordship, I pass this contract to your lordship. As per the contract, payment was due.
Where have you taken up that contention?
That in the affidavit
Then
we have not
to
taken.
argue.
It was not taken here, but taking note of this Honorable Supreme Court in that memorandum of settlement, they categorically, the Honorable Supreme Court said that both the parties had to comply, and in the memorandum of settlement, it was very much clear.
All parties to act.
No, man. That is the
All concerned.
Yes.
Word used is all concerned.
concern. Your lordship may kindly the memorandum of settlement.
Last paragraph.
Last paragraph, that is all parties do. The memorandum of settlement which accepted by the Honorable Supreme Court, that was the 4 installments required to be paid should be paid.
Correct.
That is 50% by decree holder number 1 and 50% by decree holder number 2. Payments already made by the parties should be adjusted against their respective shares.
Still you sent the money back. There is a mandate with the apex court.
Yes.
Already whatever has been paid should be appropriated.
Because of Rule 7 of the forest contractor. Your lordship may kindly that I would like to show your lordship. See. Your lordship may kindly, I am reading your lordship. Because it is a Rule 7. Rule 7 is very much time to be the essence of a forest contract.
Correct.
Time to be the essence of the forest contract. Here in the contract, the time was 15/11/77 to 15/2/1979.
But that applies to the forest contract. But it does not apply to the orders of the Supreme Court.
Order of this Honorable
Once
Supreme
it gets a seal of the court, it becomes order of rule of the court. 1921 Privy Council. It becomes rule of the court, the order of the court.
So since the time was lapsed and it was letter was written to the decree holder, that you take back your because time was.
But apex court said you appropriate that money already deposited towards the payment which is due to you. The DGA submits that since amount due was not paid, the advance was sought to be returned. And that in view of the time being essence of contract in terms of Rule 7 of Forest
Contract rules.
Forest contract rules, the decree is not executable in the absence of payment.
Forest Contract Rule 1966.
Which rule it is? Rule 7
Yes, Rule 7.
of Forest Contract Rule 1966. Next one.
Rule 7 and Rule 34 also.
Rule 7 and 32. Lord DG also submitted that the order which recorded the settlement between the private party is inexecutable because of the provisions of which is that 72 Act.
Madam?
You said 1972 Act comes in the way of
That is Wildlife
Protection Act 1972.
Yes, ma'am.
Wildlife Protection Act 1972. First, when asked as to why all that was not brought to the notice of the apex court while recording the settlement, he says that it was become ignored. Okay.
Now, your Lordship may kindly see in my note the obligation of parties to contract. When the decree imposes certain obligation on both sides, which are so conditional that performance by one is conditional on performance by other, execution will not be ordered unless the party seeking execution not only offers to perform each side. That is, AR 1995, Supreme Court 369, Jayanarayan Ram Lundia versus Kedarnath.
It submits that when the decree is conditional and the performance of one condition depends upon the other, no execution shall be levied without performing such conditions. First off, in support of this, he presses into service the decision of apex court in AR
1995, Supreme Court 359. In the note I have given.
YSC 355.
359.
359. Okay.
Then my specific submission against the decree holder that the non-performance of the settlement was attributable to the decree holders for which decree is inexecutable.
Yes, covered.
That is year 1952, Supreme Court 9, another thing. Then your Lordship may kindly see the change of law.
Very change of law.
Yeah, that is one wildlife part, then subsequently your Lordship may concede. The swimming part, reserve forest that was declared in 3/12/79, that is prior to the order passed by the Honorable Supreme Court on 27 March 1990. That is there. That then notification number 11/11/92 of the state government allowing felling of trees, reserve forest was restricted by the Honorable Supreme Court by civil appeal number 202 dated of 1997. Another, so far the Orissa is concerned. Accordingly, in compliance of the order of the Honorable Apex Court, the state government didn't permit felling of trees, even in cases of existing contract. Yes. Then third minor.
But that was when it was?
11/11/92.
11/11/92. 92.
Yes.
You had filed applications which were rejected on 27/3/28/1/94.
Yes, sir.
This was available to you.
we filed the,
You had filed IA numbers 2 and 3 in 1993.
yes,
That judgment was already there.
yes. 97, 93.
The judgment was already there. 11/11/92. They said judgment was already there. You had not taken up that.
No, 11/11/92,
Yes.
there was a notification by the state government.
Which permitted felling of the trees,
Yes.
which the Supreme Court has struck
And
down.
Supreme Court has struck down in the year 1997.
1997.
Yes, civil appeal number 202 of 1997.
All right.
Yes.
That is all right. But what about the seizure goods and other things you have sold so much? Do you dispute this?
My lord?
You have sold umpteen number of logs.
Just now my land friend passed out. I have not.
Felling is one thing.
Yeah.
But the trees dying on their own and falling to the ground like men will fall down in the cemetery is another. The fallen trees are available for coupe.
That is done by this Odisha Forest Development Corporation. That is authorized by the state government.
Correct.
They are doing
You
that.
should have authorized them. All right, don't fell any tree because that comes in the way.
Yes.
Now, whatever trees have fallen, you make coupe, ask them to come and take it.
Yes, sir.
Where did you show that fairness?
No, that I have no instruction. That just now my land friend has passed.
No, even otherwise. The only felling of trees is prohibited.
Yes.
But the fallen trees
Yes.
are permitted to be put into coupe and auction.
Now, in
Only
the,
thing is, it should be done through the agency.
yes, exactly.
Your forest development.
Your lordship, the decree holders in the prayer made before the execution court, they now change their prayer, saying that in the event this honorable court is pleased to hold that the trees so identified by the judgment debtor should not be cut to avoid ecological imbalance. The judgment debtor may be directed to supply equal quantity of logs to the decree holders from any of the depots of the forest department in the state, and cost of the execution may be shown. So that is
not possible. You then alternatively you do this one. This is a concession which he wants to show to the government.
No, in the decree, but it was not the part of settlement before the Honorable Supreme Court.
Huh?
The memorandum of settlement filed before the Supreme Court, it was not there.
That's it. This is execution of decree.
Yes.
Where you cannot pay 1 lakh rupees, then give me 97,000 rupees. Can you say, no, that is not covered under the Supreme Court order?
That was not. But your lordship has the power, the executing court has the power to construe that. That I also have given.
It was only alternatively. In fact, first prayer is that you execute that.
Yes. Then your lordship, then T.H. Godavaran case came. That is 96, 12/12/96 and 15/1/1998. T.H. Godavaran case. That also prohibited the cutting of trees in the.
In your who is asking you to cut the trees?
That was the
this court is against felling of the trees. Perhaps he is also agreeable. Trees need not be felled at all. But trees fall on their own. As we fall in the cemetery after particular years. The fallen trees, they can be couped, and whatever is available, you should have said, brother, so much is not available, only few trees have fallen down. And therefore, we are giving you so much.
With this proposal, they should have approached. They should have approached the authority.
Well, what for? You are saying it is not executable at all, and your authorities will execute it. You only are telling now, no, decree itself is not executed.
Yes.
Well, where he should go? When state is saying it is not executable, we will not abide by the decree.
Your lordship has the ample power on this while sitting in the decree. I have also brought one decision given that there is No doubt, a court execute a decree shall execute it as it stands, and it cannot modify or vary the terms of the decree. But the execution court has the power to constitute a decree in the light of the applicable provision of law. That your lordship by exercising your lordship power.
For execution.
Then scope of applicability, scope and applicability. The decree must be enforced, interpreted in a manner that the litigation between the parties is certain, also aid and of your lordship say. And for this purpose, the real intention of the parties can be gathered from the various facts and circumstances of this case, which led to the passing of the decree. Then, executability of a decree on observe of any legal title. In the absence of any legal title, now the contract was in favor, issued in favor of the decree holder number 1. Now they both filed a memorandum of settlement, and the Hon'Ble Apex Court directed both the parties to take to work out, carry out the work out according to the order. Now there is a question of legal entitlement there. There is no legal title in favor of the decree holders.
No, but order of the Apex Court will not give title. Ordinary sale deed can give, lease deed can give, exchange deed can give, mortgage deed can give, a grant can give. Highest order of the Apex Court, that order will not create title. That creates. You have done a lot of work, I understand. And that is appreciable. They generally, very few government advocates will burn a midnight oil to protect the interest of their client is one thing. That is appreciable. But implementing the highest order of the court to which you are a party is a very imperative. Because the Apex Court said, the Constitution says, which your brother 144 said, everybody should act in aid of the Supreme Court.
That I have placed before your lordship, actually the facts available before me. And your lordship
Any other submission you want to make?
Because it just came from learned senior, that we did not offer. There is a letter dated 11/3/1994. We have categorically written that please abide by the Supreme Court's order and please intimate regarding payment of installment etc. for which we will remain ever pray.
Fixed.
Both of you file written submissions. Both of you file written submissions. It becomes easy for me to look into every breach. Okay? No.
This letter which I have now submitted is not in the record. So I will put it in the notes of submission in that case.
But it will not be part of the pleadings. For that,
it is actually part of the writ application which I had filed and withdrew, because writ application and execution both cannot go simultaneously.
But how can you?
I can file an affidavit.
The leave of the court.
Leave of the court I can file, or by an affidavit I can file it. By an affidavit.
Then he will have opportunity to object to that then. Because whether it is genuine or not, all these things will arise. In your execution petition, you have not pleaded that.
No, it's in the writ application which I just.
No,
that's not necessary.
It is necessary, but I can't permit you to produce it now. That would have perhaps helped you also. That's another thing. But there are many aspects. Now put your legal submissions. Legal submission should be 2 pages, 3 pages. It should not be bigger than this file. Otherwise, I will prefer to read this file only. Is it? 3 pages, 4 pages, arising from the points which you clicked from this one.
In the notes of submission, I have already filed, which is
written submit. Now you have heard his argument.
I will incorporate.
And he has heard your argument. Both of you have heard my argument also. My notes will come in the form of judgment depending upon your notes. Okay? But I appreciate that you made lot of efforts. Heard result. Parties are given a period of 4 days for filing of
Not even next week, because
one week will give.
because of Ganesh Puja.
For filing of. Generally, I don't give because I approach the judgment very next day. But since some complexity is involved, that's the reason I'm giving time. Parties through their counsel have agreed to file the written arguments regarding head to complexity involved in the matter. For that, 1 week is granted. Yes. Okay.
Grateful.
But afterwards, I will not wait.
No.
I will pronounce the judgment. Yes. Take this also.
Item 35.
May I please?
Yes.
That Annexure 7, the order passed by the Director, Higher Education, that is under challenge. My seniority was ignored. The junior most lecturer of the college, he has been directed to take the charge of principal in charge. Annexure 7, your lordship kindly glance, page 24.
23 order.
24 is the improving order, where the Director of Higher Education, he has directed to OP4.
There is one similar matter which Kunal Sen Swain has argued. We have, which is that matter? Do you have WP number? It is
Aided college.
Aided. They have separate rules. They have separate rules.
Yes.
Okay.
That is Annexure 7, page 24. Your lordship kindly glance, my date of appointment, this is aided college.
Aided college.
I joined in the post of lecturer in commerce on 14/9/1995. The
Lecturer,
page 14, your lordship kindly, Annexure 2 series, page 14.
lecturer in commerce.
Lecturer in commerce. I joined on 14/9/1995.
He joined on?
The OP4 joined in the post, my lord. That is in 1999.
Tell the date.
My lord, he joined as mathematics 8/5/1999.
8/5/99.
99.
Are there any disciplinary proceedings against you?
No,
Nothing?
I have stated so. No proceeding is pending against me and no allegation is there also. And
Who appears for the management?
the suppose OP2 supposed to file counter affidavit, the sub-collector.
My lord, we have filed counter affidavit.
Why you have
There
adopted
is allegation of indiscipline against the petition.
discipline? Allegation by whom? When?
By the locals and students, principals.
No, what inquiries? Otherwise, you will make a junior most person you will place in charge. Generally, in charge arrangement does not depend upon seniority,
My
etc.
lord.
But it is not that simple
My lord.
because he will write the CR of these people.
No, my lords, it is stopgap arrangement till
How long?
regular is appointed.
When regular will be appointed. This is of
My lords, there is interim arrangement by this honorable court and the nearby somebody else is in charge. My lords, kindly see.
when he was placed in charge. Generally, I was of the impression that seniority need not be followed, but it will have many consequences. After hearing Swain,
My lords, there is a serious.
many aspects are.
My lords, there is serious allegation. My lords,
So allow me complete the argument.
an affidavit we have stated. My lords, kindly
These are
see.
the 3 minutes cases.
Para 8 of our counter, my lords.
Para 8, allegation.
My lords.
What inquiry you have held?
Inquiry is not
yet. Otherwise, tomorrow you will say whenever you want to favor a particular person, the next man.
My lords, there are 4 persons available.
Yes.
2 didn't want to join. They forfeited their rights. And 2 persons left. The petitioner and opposite party number 4.
How long he has been in service? 1995. September 1995.
Well,
If there were allegations, you should have sent him home. Any adverse entries made in the revenue records?
It is,
what do you call it? A CRs.
CR. Yes.
CCR.
My lords, para 9.
CCR?
Para 9.
Character.
Annual confidential report.
ACRs.
My lords, that para 9 we have stated, your lords.
Para 9 now?
Counter.
So present petition.
Counter.
The sheet as well as the honorable. No, where in the ACR it is mentioned.
Well, they have considered para 8, your lordship kindly see. Para 8.
No, paragraph 8 and 9 together I read.
My lord. That
So
is
where is the entry, adverse entry in the revenue record in the ACR?
my lords.
In fact, that counter affidavit was filed by a private person appearing for the sub-collector. This court, last order,
My lord directed to file counter by us, not by a private.
which counter it has
lawyer.
that has been placed, your lordship.
You have not filed counter also.
My lords will file, your lordship.
No, you
No, it is filed, but by a separate person. It is.
how the counter should be filed by the concerned jurisdictional official.
My lord. That is why.
Otherwise, he
Honorable
is
court
also
denied.
interested. Person who filed this counter
My lord.
is interested or he has got something.
Is the sub-collector?
Person
Sub-collector.
you have put in charge.
My lord.
Perhaps he has greased his palm. On what basis you are doing this? That will hurt the employees.
My lords, in absence of any malafide, my lords.
No question is not only malafide. Norm of jurisprudence. Why you want to favor a junior and disfavor a senior?
My lords, the reasons are assigned, may not be in proper form, but.
No, in substance also. Not only form, in substance also.
We will file.
On the ground that which is the nearest market near Cuttack? Any name of the market?
Chaudhary Bazaar.
In Bazaar, they said this person is not good, therefore we have not given in charge arrangement. Can it be taken note of?
My lords, we will file fresh counter.
So where is the requirement of filing the counter now? Even otherwise, going by this also, there is nothing. Worst come worst, I will permit you to go by this.
My lords, see, it is a stopgap arrangement. My lords.
How many years it will go on? When did you appoint? When did you?
Until regular appointment is made, my lord.
No, that's all. But that will not take place for years. And for all those years, he will trouble him. But it should not be. No, times have changed. Where you cannot make junior. Not only that, it gives scope for playing mischief to the quarters that be. I will not say much more than that, because in transfers, people are interfering. And in this also it will happen. And where will be the autonomy of the educational institutions tomorrow? Instead of teaching here, all they will be at the corridors of the power.
Well, lords, annexure C/2, the allegations.
C/2.
Well, students have alleged that petition.
Knowledge, why you should have looked into. You should have told him, brother, your students are saying very ill of you. What is your explanation for this? I don't say holding inquiry. Some explanation from him. Otherwise, you will be acting upon
Probably that is the.
Anybody can play mischief by sending allegations against the teachers, as allegations are made against the judges, some lawyers also. That should not, that will not augur well. If there is allegation, you should have put it to him. Where there are some allegations against you, you should have called those students and asked them, you have made these allegations. Are they good or bad? Otherwise, you will generate allegations. For any people's representative, generating allegations of the kind is a job of 2 minutes.
And they are not the students, Your Lordship. I have the file rejoinder affidavit.
Therefore, I said, market.
Your Lordship.
You appear for the incumbent.
Lordship, I am appearing on behalf of Mr. D.R. Gupta. On behalf of Mr. D.R. Gupta, Lordship, for opposite party number 4.
4, would be 4.
Yes,
what's your title to hold that post now? Given on in charge basis.
I am not in the post because an alternative arrangement was made by this honorable court.
Alternative arrangement is
already made. And your Lordship,
by way of what?
Another person has input from other college.
My lord,
nearby
college principal is in charge.
In charge.
Lordship. It is up to regular.
No, that regular, I don't understand. It is like chancellor's foot from 9 inches to 13 inches.
Well,
when are you going to make appointment?
That instruction, I don't know. Lordship, for a moment, I may clarify, Your Lordship. Your Lordship, there was a notification which my learned senior is referring to under Annexure 5 of the writ petition. The said notification dated 31/8/2020.
That was passed. That is
one minute, sir. The same was under challenge before this honorable court.
It was fast, you can go to that level.
It was
a challenge, the stamp paper was attached, the arguments took place, and judge said, all that, what is that? It is questionable.
It was quashed. And thereafter, state government was directed to bring up any fresh
norms.
Fresh norms regarding the appointment of principals. Thereafter, Your Lordship, on dated 8/11/2024, the state government has
framed
the guidelines, Your Lordship, where may I read?
Only relevant.
Guidelines for posting of principal in non-government aided colleges under higher education department, where it says that any reader can be appointed as a principal in charge of a non-government private aided college, non-government aided college.
Properly has not been read. The language has not been properly placed, Your Lordship. Can you glance?
Read.
This says only teachers from the common cadre of readers grade are to be appointed as principal. However, if no eligible or willing readers are available, eligible and willing senior most lecturers can be appointed as principal.
Then it's all
that thing, Your Lordship, to clarify whether anyone
stays here. But not by argument. It's in a document.
Your Lordship, but they have to clarify whether anyone have applied or not.
Yes, that.
That is supplying in shape of memo also.
Paragraph, which is that paragraph?
That paragraph A, 1, 2. However,
paragraph 8.
Paragraph 1, eligibility. There are 2 categories. One is 448 category colleges.
Correct.
That has been.
You fit into which college?
Yes. I am coming on 448 colleges. That's second paragraph. However, if no eligible and willing readers are available, eligible and willing senior most lecturers can be appointed as the principal. I am the senior most college of the lecturer of the institution. And what my friends submitted that notification that is set aside is not fully set aside. In the Your Lordship, while setting aside this honorable court held.
You are 488.
488 category.
But the one which you are using reading is 662 category.
Another is 62 category colleges.
Where is selection I am based on seniority among the eligibles.
Yes. 2 category.
Selection process.
I am in 488 category.
488.
488. Which is that order whereby in charge arrangement is made by the government?
That is Annexure 7, Your Lordship.
Article 7.
No, that
No, my lord. That is why order dated.
that is why
Pursuant to interim order.
My lord.
pursuant to interim order.
This order whereby your
30.
junior was OP4 was made.
No, another person.
Another person from outside nearby
Outside.
college.
No, you have made OP4 the party because he was placed in charge.
He was
No,
directed to take in charge.
In charge.
That was stayed.
That was stayed.
Subsequently, by alternative arrangement, this Hon'Ble Court directed that another person be,
That order is dated.
Miller, that the order.
34/2024 of this honorable. 34/2024.
34/24.
34/2024.
Right now. Can you be seated? In your seniority list, we are at serial number what?
Miller, in the senior list, I have supplied or seen. I am in serial number. Serial number 1, page 23.
And OP4 is?
OP4 is serial number 4.
And the person now who is appointed as in charge from other college?
Nearby college.
Nearby college.
Nearby.
So he has to leave that college and come here and he sit here principal.
As a principal in charge, your lordship.
Now in charge means he has to enter the principal chamber and sit on the chair.
Yes, your lord.
Or from remote control he will do.
No.
How many? What is the distance between that college and this college?
No idea. Lordship.
What is the distance?
My lords, I don't have idea. But what I suggest, my lords, your lordship may direct for regular appointment so that that problem will.
Regular appointment takes place, let him sit in the chamber.
Your
He
lordship,
should be deprived of.
your lordship may grant 1 month time so that in the meantime regular appointment will be made. In charge person can.
As long as you do not want to make regular appointment, I will not say regular appointment. It is your duty to make regular appointment.
My lord.
I will not say. Till regular appointment is made, what should be done? I can say that.
My lords, that arrangement was
Will
made.
continue for years.
My
Till
lords.
regular appointment is, it all depends upon his proximity to the power.
What I humbly submit, my lords, the arrangement was made by this honorable court only.
It was an interim arrangement.
Yes.
He came here not for making interim arrangement. He came here that injustice is caused to me. You undo it. How more justice is caused to another person is not his grievance. It was only interim arrangement. In the wisdom of the judge, it might have been well. But I would not have made it. Is another thing.
Yeah.
But I have to respect my brother because it all depends upon perception.
My lords, only only for the allegations, otherwise nothing.
That can never be a ground at all. Only things that are entered in the register, CR, some disciplinary inquiry, or some sexual harassment at workplace, or some criminal case, or highly inefficient. That is not your case.
Only show favoritism.
Huh?
Only showing favoritism.
Otherwise, a lot of favoritism. Our object of rule of law is to minimize the discretion and make things normative so that discretion shall not be abused. That is the end game of every constitutionalism. That's the end game. Because man being what he is, Thomas Hobbes, which Salmon refers, he said man is a rascal. And Oliver, that famous American thinker, Ralph Waldo Emerson, he said, man was a rascal before 2000 years ago. Now he is a literate rascal. So all these things I have to keep in mind and make the judgment. Take up. OP number 4 came to be placed in an independent charge. In charge or independent charge?
Principal in charge.
Placed in the seat of principal of the institution concerned on in charge basis. Wide order dated 34/2024.
No, Your Lordship.
23.
23/11/2023.
23/11/23.
Lord, 23/11/2023. Annexure 7.
At Annexure 7. Ignoring the claim of petitioner and therefore he is knocking at the doors of the court. First, next paragraph. Kindly be seated. Learned counsel for the petitioner vehemently argues that ordinarily, whenever vacancy arises in the office of the principal, the senior-most person eligible for promotion to the said post, he is placed on in charge basis or independent charge basis, subject to all exceptions, into which the case of his client would not fit. Semicolon. Petitioner tops the seniority list, whereas OP number 4 is at serial number 4, comma, two more persons being sandwiched, namely at serial number 2 and 3, comma, who are said to be unwilling to accept the arrangement of the kind. First, therefore, the impugned order be quashed, coupled with a direction to award in charge arrangement in favor of the petitioner, comma, argues the counsel. First, next paragraph. Learned AGA appearing for the official OPs 2 and 3, and learned counsel representing OP number 4,
Abhay Khandelwal, on behalf of Mr. T.R.
opposed the petition, contending that the concepts like in charge arrangement and independent charge arrangement are not alien to service jurisprudence. Semicolon. In making such an arrangement, comma, ordinarily the seniority is not the thumb rule, comma, a host of factors entering the fray of decision-making process, keeping in view the administrative efficacy level of the possible candidate. First off, they also submit that arrangement of the kind is temporary in nature, and therefore much grievance cannot be made by the seniors. First, so contending, they seek dismissal of the writ petition. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number 1. Justice Rama Joyce, in his services under the state, discusses about the concept of in charge stroke independent charge arrangement as at that. First, that was the position way back in the year 1984 when things were running arguably consistent with the fairness standards. First, the Karnataka High Court in Basavaraj N. Dhotra versus Chairman Land Army Corporation, take out that judgment. 1994 or 95, which one? Honorable Justice Nadir's judgment. Referring to Justice Ramajoyce's observations above, held that rule of seniority ordinarily would not be applicable to in charge stroke independent charge arrangement. V.N. Dhotra or Basavaraj N. Dhotra. Not M, very Basavaraj N. Dhotra. N is separate to initial time. Basavaraj N. THO. TRAD. Take out that. Year 19. No. B. N. DHOTRAD versus Karnataka Land Army, KLEs, Karnataka Land Army Corporation, something like that. Can anybody help? Got the point? Right now. ILR 2006 Karnataka 3163. What you have written now? Room law. Shall not be applicable to, it should be all of it. First up. Next paragraph. The above being said, now there is a state policy dated 8/11/2024, wherein the placement by way of independent charge, in charge stroke independent charge has been made normative. Keeping in view the type of, the category of institutions. This is for regular appointment only.
Yes.
Not charge arrangement. The relevant part of the policy reads as under.
In that college, there is no reader. No readers are there.
No readers are there. I have mapped it. Whatever it said. The above being said, comma, now there is state policy providing for appointment to the post of principal on regular basis, which prescribes certain terms and conditions of eligibility and qualification. First one, it is desirable that the said policy should be operative even for making appointment on in charge arrangement till a regular appointment is made. First one, a rule of law requires that the level of discretion should be decreased as much as possible. Man in power being what he is. First one. Next paragraph. It hardly needs to be stated that the management should conduct itself in a fair and reasonable manner while treating its employees, be it in the category of or otherwise. First one, in a contra condition, heartburn would happen, and that would dampen the spirit of committed employees, more particularly in the teaching institution, in the educational institutions, which in turn would affect the interest of the community of the taught. First one. At the same time, there may be cases of exception, is also true. First one. However, the petition does not involve such exception. First one. Next paragraph. The vehement submission of learned AGA that there were some allegations against the petitioner hearing, and therefore he was not given the in charge arrangement of the post of principal is bit difficult to countenance. First off, even an upright person does not escape from criticism and allegations. First of all, unless an official is charge sheeted in a criminal case or a charge memo in disciplinary proceeding has been issued, the candidature of such a person has to be considered even for the placement on in charge basis. First of all, the rules of reason and justice eminently warrant. First of all, in the instant case, there is no disciplinary proceeding or a criminal case pending against the petitioner, admitted. First of all. No adverse entries in the ACR are also brought to the notice of this court. First of all. Therefore, the petitioner had every right to stake his claim for the office in question on in charge or independent charge basis. All the above being said, next paragraph. Come on. Arrangement like in charge or in charge cannot be continued indefinitely to the prejudice of administration of office of principal, stroke head of the institution. First of all, ideally speaking, it should be for a short period, like 6 to 8 months, in as much as an in charge holding person has no right of lien to the post, and therefore he cannot discharge substantive functions of the office as held in P.N. Patra. So, first of all, therefore, the state should make immediate arrangement for undertaking appointment to the post in question, not only in this institution, but all such other institutions for selecting and appointing regular principals, stroke heads. First, next paragraph. Learned AG contended that a coordinate bench of this wide of interim order dated 30 April 2024 had 30 April, yeah, all right, 2024 had entrusted the charge of the office of principal to a reader from other institution, and therefore the same position should be continued. First of all, this is a bit difficult to agree with. First of all, the citizen, the aggrieved citizen, is before this court not for seeking appointment of some other person from some other institution, but for staking his claim for holding the post in question on in charge basis. First of all, he has not only a legitimate expectation, but the support of rules of reason and justice. First of all, an outsider will not be able to discharge his functions in the institution. Obviously, for the reason that he is an outsider. First off, this view gains support from broadly gains support from HP Lakshmi Narayana versus KFDC. Just put I give that judgment. Okay. Next one. In the above circumstances, this petition semicolon. The impugned order dated 23/11/2023 at an exam 7 is questioned by issuing a writ of certiorari. First of all, a writ of mandamus issues to whom? Who should appoint you?
3 Lords, OP3.
OP number 3 to place the petitioner in the office of the principal of the institution on in charge basis forthwith and report compliance to the Registrar General of this court within an outer limit of 4 weeks.
Till regular appointment is made.
It is made clear that this arrangement would continue only till after a regular incumbent enters the office.
The Lordship said that by interim order, the court directed that reader to be appointed the senior lecturer. The court, as the interim measure, directed to engage any senior lecturer or other locals to appoint. Paragraph 7.
Instead of reader, lecturer.
Senior lecturer.
All other matters will come, we distribute them based upon because we have already calendar is full. But
My lord, item number 53.
I am here for another 10 months. Therefore, you can make an excuse of
There is an interim order is there, my lord.
wherever interim order.
Item 60 alerts, small matter. Immaterial withdrawal. Small matter, tomorrow Monday alerts. Item 60 alerts.
Chalo.